The Appellate Division First Department is now in session. Good morning. Welcome to the Appellate Division's First Department's virtual argument session. Please listen carefully as I will now call the calendar. People versus Lamont Shumaki, submitted. Ellis versus City of New York, submitted. Stephen K. versus Marina M. Appellant.
Stephen Forbes, appearing on behalf of the appellant. Good morning, Your Honor.
Good morning. 5 and 2. Respondent. Respondent.
Galina Feldman.
I didn't hear that. Would you repeat?
Galina Feldman.
Okay. Galina Feldman, 6 and 3 for the respondent. Arias versus Stonehard, Inc.
I'm sorry, Your Honor. There's also an attorney for the child on that last case that's arguing.
Okay, thank you. I'm sorry, it's 6 minutes, and then the attorney for the child, 3 minutes.
Thank you, Your Honor.
Thank you. Arias versus Stonehard for the appellant. Stonehard.
Seth Weinberg for surfaces, Your Honor, appellant surfaces.
The surfaces, okay, 6 and 3, and for Stonehard? Is Michael Cena here for Stonehard? You're muted, sir. I still cannot hear you.
Can you hear me now?
I can, yes.
I'm sorry, Michael Senna for Appellant Stonehard.
Okay, thank you. 6 and 3, Mr. Senna.
Thank
And
you.
for the respondent,
Good morning, Your Honor. Brian Martin for respondent Arias.
7 minutes, thank you. Cruz versus New York City Health, submitted. Sports Technology versus MLB Advanced, submitted. Unitrend Direct Insurance versus Beckles, submitted. Deutsche Bank versus Afram. For the appellant?
John Caracciolo for the appellant, Your Honor. Good morning.
Good morning. 5 and 1, Mr. Caracciolo. And for the respondent?
Good morning, Michael Maniello for the respondent, Your Honor.
And thank you, Mr. Maniello, 5 minutes.
Yes.
People versus Joseph Ferrigno and People versus Aaron Wickham.
Yes, good morning. Good morning, Your Honor. It's Richard E. Michel. I'm a off of Mr. Ferrigno, but I will be making the argument for both Ferrigno and Wycombe, and Mr. Tauger will be doing the rebuttal.
Who will be doing the rebuttal?
David Tauger, who is Mr.
Tauger.
Wycombe's lawyer.
Yes, thank you. And for the people?
Brent Ferguson.
I'm sorry
for the
if I
people.
wasn't clear. That's 7 and 3.
That is correct, Your Honor.
Okay.
you.
And for the people?
Brent Ferguson for the people, Your Honor.
Thank you. 5 minutes, Mr. Ferguson. Brooke M. versus Christopher M. Submitted. Empire Center versus NYPD Pension. For the appellant?
Good morning, Your Honor. Cameron McDonald for Empire Center for Public Policy.
10 minutes, sir. For the respondent?
Good morning, Your Honor. I'm Melanie West for the pension fund.
Thank you. 10 minutes. Costa versus Arandia and Arandia, submitted. Potenza versus City of New York, submitted. Kasowitz Benson versus U.S. Ambassador.
Yes, Stephen Storch, Your Honor, for the appellant.
And that's 5 and 2.
Joshua Siegel for
The
respondent.
respondent.
Joshua Siegel for respondent.
That's 6 minutes. 111 West 57th Street versus 111 57th property. There are 2 appeals here. For the first, appellant on 111 West 57th. Appellant, I believe Mr. Meister. Is the respondent here?
Yes, Your Honor. It's Paul O'Connor for the respondent in both cases.
Okay, I just heard a sound, maybe.
Yep. This is Paul. Did you hear me, Your Honor? Paul O'Connor?
I heard you, Mr. O'Connor. I'm still waiting for Mr. Meister, and I heard a beep. I thought it might be.
He was having a lot of trouble getting on before.
Okay, so let's hope that by the end of the calendar, he's back on. And Martinez versus DeFiore.
Good morning, Your Honor. Renee Cathawala for the appellant.
5 and 2. And for the appellant, for the respondent.
Good morning, Your Honor. Matthew Grieco for the respondents.
Thank you. And Camara versus 767 Fifth Partners is submitted. I'm going to be calling 2 cases in a different order, Kasowitz and Martinez, as we both have justices recused and we'll have a justice vouched in. So those 2 cases are going to be called at the end of the calendar. Okay. So counsel, please, as always, remember that we have your briefs, we have your record, and we're fully familiar with the facts of your case. So please go directly to the most important points you wish to make. Also, as is customary, please don't speak when a justice is speaking. This is, of course, particularly important during our virtual arguments in order to hear the questions that are asked. And finally, please keep your mics muted until your case is called, but do remember to unmute when it is time. Thank you for your patience and cooperation. We're ready to begin. The first case for argument is Stepan K. versus Marina M. And that is Mr. Forbes, I believe.
Yes, Your Honor. May I start? I'm not really sure how this is working.
Yes, thank you for asking. You have 5 minutes and you may begin now.
Okay, thank you. Good morning, Your Honors. My name is Stephen Forbes and I represent Marina Matvienko. Hopefully everyone can hear and see me okay. I'd like to thank the court for the opportunity to just briefly address some of these issues. Basically, in the respondent's brief, they reference false allegations that were made by my client, and over again during their brief, they refer to sex abuse allegations that my client supposedly made with regard to the father. And I would just point out to the court that and while the father himself was testifying in May of 2018, he specifically indicated that the allegations that were being made against him had to do with domestic violence and not sex abuse, and that he also took a plea to that charge, which took place in criminal court. So in essence, what the respondent is claiming is that my client.
This is Justice Gesmer. Wasn't there an incident in 2015 where she accused the father of, quote unquote, sexually harassing the child?
Not to my knowledge, but the way it's presented in both the respondent's brief and the attorney for the child's brief is as if this were established. There was an arrest of my client in 2017, and that case was not resolved. Still not resolved, as far as I know, while the case in the IDV court was pending. So essentially, what both the respondent and the attorney for the child's attorney are suggesting is that these are established facts when in fact they are not. The other aspect of the interference that they're claiming is that my client traveled internationally with the child without properly informing her. The court will note from the stipulation that was formed the basis of this, in which the respondent sought to modify, did not specify that she was required to supply him with anything in writing, and she did testify that she notified him orally of her intention to travel. Which she did frequently with the child when the child was younger. And I would just...
The stipulation did require that she give him contact information so that he could be in touch with them, correct?
Exactly, it sure did. And the father specifically said that he never had any contact information for her while she was traveling. And at the same time, in the very next breath, he said that he was trying to email her, never produced copies of any of those emails, was trying to call her, was trying to reach her through Skype. So he clearly had contact information for her, in spite of the fact that he was claiming that she was traveling without providing him with any contact information. So that much was clearly not true. And I would just also point out to the court the circumstances that these parties found themselves in the 2015-16 up until 2014. In fact, up until the time that he actually got custody, the father had never even had an overnight with this child, and had not been didn't even seek to have visitation until he was ordered to pay child support in June of 2014. That petition he didn't even bother to finish up with that petition. He just instead decided to go proceed with the divorce proceeding.
Well,
And
counsel, can I ask you a question? I mean, that's,
Sure.
I think he admitted that in the first couple years, he didn't have that much contact with the child. But Judge Dawson in the IDV part wrote a very long decision after the trial in this case, and went through all the testimony of all the witnesses, and seemed to have been very familiar with the case for several years. So she was aware of that point, but she was weighing a lot of different situations where he did get custody starting in temporary custody, I think in 2014, and then was taking care of him, even though there was the problem before. So she was aware of that. And that was one of the factors she weighed, didn't she?
Well, first of all, I just wanted to correct what you just said. You said that he got custody in 2014. He actually got temporary custody in January in 2017. And just, I see I'm running close to the end of my time. So I just want to point out, number one, that temporary order of custody was improperly entered because it was done without a hearing. It was done on the very first court appearance. The second of all, she had the access to a forensic evaluation and a report that was never admitted into evidence, even though the court actually reviewed it itself, which was also improper. And when my client never was given the opportunity to cross-examine that and explore the issues raised by them. By the forensic evaluator. I see that I'm out of time. May I just...
Justice Gessmer, you are muted.
Counsel, was that issue preserved with regard to the forensic report?
I believe that it was. I mean, the counsel had argument in front of Judge Dawson seeking to have the forensic evaluator called as a witness, and that conversation that never happened. So whether that issue was preserved or not, the court actually indicated that it had reviewed the forensic evaluation, and as a result, some part of the court's determination could very likely have been based on information that is not on the record before this court. And for that reason, I'm asking for the court to reverse the determination of the IDV court. Thank you.
Thank you. I think it's Mr. Feldman, is it?
Ms. Feldman, thank you, Justice.
Ms. Feldman, I'm sorry. Yes. You may begin.
Can you hear me well?
Yes.
Thank you, Judge. First, I wanted to apologize before this court. My server crashed this morning. I don't have access to my brief. I'm doing it from the memory, so please be patient with me if I forget something and need a moment to think. If I may be heard, Your Honors, the trial court's decision to transfer custody to the father had a sound and substantial basis on the record, and it should not be disturbed. First and foremost, it was established at trial that the father was the only parent that was able and capable and willing to make sure that Adrian has a relationship with both parents. The father testified, and it was shown at trial that he is able to provide for Adrian's needs. The child was going to school, unlike when the child was with the mother when she traveled for 3, 4, 5 months at a time out of the country. The child was absent from school. The father even given more time than the court ordered because he felt that it was important for Adrian to reunite with his mother, because the child expressed that he misses her. So my client, Mr. Kuzev, went beyond of what was ordered by the court and allowed the child to spend more time, which Ms. Matvienko used to once again made false allegation of child abuse against Mr. Kuzev, none of which were found to be valid. Mr. Kuzev was arrested twice because of the false allegations Ms. Matvienko made that he was assaulting her, beating her in front of the courthouse after the parties left family court. As it turned out, those allegations were false. My client was able to produce a video of him being in a completely different side of the city at that time of the alleged incidents. And as a result, Ms. Matvienko was arrested at the airport when she was coming back with the child from Ukraine, from yet another trip to Ukraine. She took the child to without notice, without providing the father Skype access that he had pursuant to the stipulation. My client wasn't able to wish Adrian happy birthday on one travel, even wish his child happy birthday. And Ms. Matvienko, it was established at trial that Ms. Matvienko actually lied under oath by submitting false statements to prior court, saying that the reason why he couldn't reach the child is because she was in a rural village in Ukraine and had no internet access, when in reality, at trial, it was established by evidence, by passport of the child, that she was in Thailand. So yes, it's correct that the mother's criminal case is still pending, but the arrest is a fact. The allegations and the charges against the mother are a fact, is that she filed a false police report. Just give me a moment, I'm sorry. So to sum up, it was established at trial the totality of the circumstances in this case supported the finding that the father should have custody of the child. Thank you.
Thank you. Is it Ms. Nothenberg?
Ms. Nothenberg, yes, may it please the court. Shireen Nothenberg on behalf of the child. Your Honors, first I just want to clear up some issues raised by appellant on the record regarding allegations. The father on May 31st, 2018 testified at page 78 of that transcript that the mother had in fact alleged that he fondled his son's genitals, which turned out not to be true, of course. And this is one of many, many allegations this mother has made against the father, only for one purpose, which is to keep this child from developing a relationship with his father. And I think what's remarkable about this litigation is that throughout the proceeding, and including at this appellate level, the mother has never recognized that this son loves his father and that they deserve to have a relationship. Time and time again, she's done nothing but try to break that bond. And I think we can all agree that that is, by definition, not in the best interest of my clients. So I just want to make sure we keep focused on the fact that never once has she acknowledged that the father deserves and that her child deserves to have a relationship with his father. And I think it's also interesting that one of the arguments leveled against the father is that he's not in tune to the child's emotional needs. Well, what's not in tune to this child's emotional needs is this non-stop litigation and the failure of the mother to abide by the court's rulings and the failure to recognize that this is a child that has two parents, both of whom have a right to parent this child. I present to you the facts that throughout this litigation, she's continued up until December 2020 to make allegations against the father. And it has not been in my client's best interest to have to be in a situation where the parents are having these disputes. And the trial court well understood that, and also understood that my client is attached to his mother, which is why she allotted liberal visitation to the mother. I think there's a sound and substantial basis in the record for this court's decision, and I urge this court to affirm it. Thank you.
Thank you, Ms. Nothenberg. Mr. Forbes, you have 2 minutes.
Yes, thank you. Just very briefly, both counsel now indicate that they believe that the father is better suited for dealing with Adrian's emotional needs. After recognizing the fact that the child was traumatized from being separated from his father, the father did absolutely nothing in terms of getting the child therapy.
I think the counsel, didn't the father respond once it was brought to his attention that it was important to have him seek therapy? As I think my colleague noted before, the father may not have been, I think he admitted that he may not have been as attentive in the beginning, but certainly has stepped up since he's had temporary custody of the child and has been caring for his dental needs and medical needs and any sort of therapy and other support, and most importantly, allowing the child to have a relationship with his mother, as counsel for the child has pointed out.
Actually, it was my client that brought the child to the dentist, and it was actually my client that brought the child to therapy with her and did.
Did the father thwart any of those efforts?
No, but the child was in his care for over a year and a half when he didn't get the treatment for that child. The child was given custody of this child in January of 2017. My client's unsupervised.
Is the father preventing the child from getting any of the services the child needs to be healthy? Since that 1 year that you've talked about, has the father done anything to thwart any of those efforts?
Well, I'm referring specifically to that 1.5 year period of time where he didn't get that.
You said 1 year before, just to be clear.
I'm sorry?
You said 1 year before, just to be clear.
It was from January of 2017 till June of 2018 when my client's unsupervised visits were reinstated. And it was during that same period of time where he didn't get glasses for the child. The school had to get the glasses for the child. I would just end on the fact that counsel indicated that the arrest is a fact. The arrest is a fact. It is an arrest. It is not proof of anything that my client actually made the false allegations. And Judge Dawson had that case in front of her, and it's still not resolved. Thank you.
Thank you. Thank you all. Next case for argument is Arias versus Stonard, Inc.
Your Honor, Michael
Just
Senator.
wait, just one moment, please. Okay, thank you, counsel.
May it please the court, Michael Senator for Hertzfelder Rubin for the defendant appellant Stonard, Inc. The plaintiff has spent 10 years litigating this case as a routine slip and fall case. Now, after all this litigation, they submitted an expert affidavit to try to create a new case, a new theory, and a new claim in this matter, which is simply not sufficient. Stonard is a manufacturer of an epoxy flooring. They don't control, maintain, or own the premises where this accident happened at the Grand Hyatt Hotel. Nevertheless, in their brief, the plaintiff refers 10 times to negligent installation of the flooring. Stonard did not install the flooring. It was installed by the co-defendant Surface Systems. Plaintiff claims that he slipped on a dry floor. And the accident, Your Honors may know, the plaintiff claims he slipped on a dry floor on September 19, 2006, while he was carrying trays to a dishwasher at the Grand Hyatt Hotel on the 5th floor kitchen. The closest explanation he had for the accident is at page 724 of the record, where he says he slipped because maybe the floor had not been laid properly. As I mentioned, Stonard did not install the floor. Really, the gravamen of this case, when you take a look at their claims, is that they're claiming that the floor was unusually slippery, dangerously slippery. And that's in the amended complaint and the bill of particulars, which talks about the tiles not being slip-proof. We know there were no tiles in this case.
Mr. Senator, was it true that it was actually the people at the Grand Hyatt that chose specifically what type of floor they wanted, whether they wanted a number 3, number 2? Were they the ones that did it in conjunction with your client, the manufacturer?
Absolutely, Your Honor. That's at page 634 of the record. In this case, the hotel and the general contractor are sophisticated parties. They made the decision as to what texture to be used. And the reason is it's a balancing, because the higher grade texture, the coarser of the material, the more difficult to clean. So they made a decision based on looking at what is appropriate for their needs. And that's so if there's an issue of whether the textures are inappropriate or they should have done a higher texture, it was a decision made by the hotel in balancing their specific needs.
Counsel, you're the manufacturer of the product, and you provide the product. Do you give instructions as the manufacturer of how the product is supposed to be laid, how it's supposed to be? And then, of course, Surfaces would apply it pursuant to your instructions? Well,
there are certainly guidelines. Surface is an experienced installer. They're our exclusive installer. So there's certainly a relationship, and they know how to install a floor. We don't sit and monitor.
I understand you don't supervise. I'm not saying supervise. I'm just saying, are there instructions as the manufacturer of this product of how to install it.
Yes, it's a four. Yes, we work with them and explain how it's supposed to be done in the
And
beginning.
so when you have these different levels of the sand-like substance, are they to be mixed? For example, can a 2 be mixed with a 3? Can it be mixed together? I understand different placements of a 2 separate from a 3, but can they be mixed together?
They can be mixed together. There's no, what it is sand. So you have
different grades
of coarseness of the sand. There's no problem about mixing them together at all. But in this case, actually, they were not mixed together. There's only texture 2 is used in the main part, and texture 3 was used.
Yeah, the ice.
By the ice machine.
My question was different than that one. Yeah.
Yeah, you could mix them together. There's no problem at all with mixing them together. But then you get back to the basis of their opposition is somehow a testing that our expert did on a wet floor, on an exemplar of a wet floor. And their expert runs with that and says that that is insufficient to create a question of fact. The fact of the matter is that this court has ruled many times that results of coefficient of friction testings are not sufficient to create a question of fact. And we would cite the Kalish case, which is in our reply brief. More importantly, though, just as importantly, the only standard in this case is an ANSI standard, which says that a 0.42 is acceptable. It's acceptable as a floor. So to argue that is defective based on results of 0.42 are not adequate. Really, what you're left with is the personal opinion.
This is Judge Kern. Plaintiff's expert never disputed that it was an acceptable level. Isn't that correct? That they said that it was acceptable.
He does say acceptable.
But acceptable.
He does say it's acceptable, but he's saying it is a personal opinion. You should have a much higher level, and that's exactly what.
Is there any deviation he showed from an industry standard?
And that's the problem. There's no deviation from an industry standard. It's his personal opinion, and that, Your Honor, is I submit is ipse dixit. The only standard that applies, that floor met, and it's an exemplar. Plus, Your Honor, the problems with their expert, there's really no foundation for his opinion. He's never examined the floor. He's never tested the floor. He never asked for the Stoneheart sample to do his own test. He never even saw photographs of the floor. So what you're left with is a 10 years after the fact coming up with an opinion to support a case which we submit is not recognizable under the law.
Thank you, Mr. Sina. Thank you. Mr. Weinberg?
Good morning, Your Honor. Seth Weinberg with Morrow Lilling the Party for Surfaces. Obviously, we agree with everything Mr. Sina has pointed out with regard to the nature of the floor. I would just add that separate and apart from that, Surface is entitled to summary judgment because it merely followed the directions and instructions of Stoneheart, who was actually the entity retained to install the floor. They retained us to do the work. We followed their directives and the plan as laid out by the customer relayed to us through Stoneheart. And there is no evidence that we should have known somehow this floor was so inherently dangerous it could not be installed. And therefore, there's no evidence of negligence as to Surfaces, and the court's finding that we launched a force or instrument of harm should be reversed. I also want to briefly touch on the post slip and fall subsequent accident of another supposed worker. And the entirety of that evidence is found at pages 305 and 6 of the record. And the question was, did you know anyone who ever slipped on the floor prior to that time? Answer, I heard somebody after me, but I don't know. Question, this is after your accident? Answer, Question, who was that? I don't know. They had to put another layer. So absent from any of this testimony is who this person was, who told plaintiff that this person fell, where this person fell in the kitchen, why this person fell, any evidence indicating there's really any connection.
Counsel, there was never any non-hearsay evidence regarding a post-accident, a further incident, correct?
Correct, and therefore it can't be used to raise a question of fact as plaintiff has tried to do in their brief. Similarly, with regard to subsequent repairs, this court has never held that a subsequent repair can be used to establish negligence. And the only case in plaintiff's brief that comes close is the Franklin case. But what this court held was that absence evidence of a subsequent repair, quote, any error in permitting testimony about the concomitant repair was harmless. Not that it was proper, it was just harmless error in the context of this case. And we can't allow a harmless error at trial to raise a question of fact on summary judgment. And just briefly on the issue of indemnity, you know, it's our position no party is negligent and therefore Stoneheart doesn't need and is not entitled to indemnity. But under the terms of the contract, if Stoneheart is negligent, they're not entitled to indemnity. So if they're still in the case, they can't get indemnity. If they're out, they're not entitled to indemnity. So either way, there's no basis for indemnity. If the court has no other questions, we'll rest on our brief.
Thank you.
Thank you.
Respondent? Mr. Martin, I believe.
Good morning, Your Honors. Brian Martin with Spiegel Barbado for Mr. Arias. In all due respect to my adversaries, I have to disagree. This is not a new theory. It's not a new claim. This is a situation where a worker goes to his place of employment. There's a brand new floor that's been put down. And he gets to work, he steps on it, he says, oh, this isn't right. This is slippery. Why am I all over the place on this? His manager, he testifies, tells him, oh, they didn't do it right. They're going to replace it. A few hours later, in the course of his work, he slips and falls. They then tear out the floor, grind it down, resurface it. The repair record for the material says we have to match the surface texture to what is over here by one of the other machines. We then have a disagreement.
Just let me, I'm sorry to stop you. Remember where you are. What you're saying is what was over by the ice machine, texture 3 versus texture 2?
There are 3 or 4 different opinions here between the defendant's 2 experts who disagree with the defendant's witness.
That's not what I'm asking you. You were talking about what was done afterwards, which we don't usually look to, but you were saying that the texture around was being ground down to match another texture. I'm asking you, was that to match texture 3, which was near the ice machine? Or
that's not clear. That's not clear, Your Honor, because they mixed 2 and 3. And
so what
texture was used by the ice machine is not clear from their records.
With regard to 2 and 3, your expert, Dr. Witt, indicated that it was acceptable. 2 is acceptable. So according to the ANSI standard. So how do you, so if it's acceptable, how does that raise an issue here?
His analysis is different. His analysis is you must evenly mix the texture, which was not done here.
Counsel, does your expert, I'm a little confused because that seems to be your primary argument, that there was a mixture of uneven textures and that's what caused the accident. If that is true, what is the industry standard that is violated by mixing different textures?
I don't know if you can directly answer that because it's not the industry standard. The industry standard is evenly mix. Whatever gets put down, assuming that the material meets the industry standard, you have to apply it evenly. And the problem here is the application is not even. We know it's not even. They put it in writing.
What do you mean that it's not even?
You have to evenly mix the texture. You can't create different slip resistance in different areas of the floor, because what will happen is, as Dr. Witt describes, and I would submit a reasonable juror to their ken could divine, is if your foot sticks more in one spot than another, what's going to happen is you're going to slip.
So your argument is that you can't have 3 in some areas and 2 in other areas? Is that what your argument is?
Not without putting it down evenly.
But you're not saying, just to be clear, you're not saying there's a problem if within the area of the ice machine there was a number 3. You're saying that then throughout the rest of the floor, where there should have been 2, there was a mixture of 2 and 3? Is that what you're saying? Or are you saying that because it was near 3 was near the ice machine and the rest of the floor was 2, that was a problem?
It would actually be both, Your Honor, because you would have 2 things. You would have, one, the uneven mixing of the grit away from the ice machine. And then the areas using 3 as opposed to the mixture would have a different slip differential as well. And
but what you're arguing is that where he slipped, which was near the dishwasher or the place to wash dishes or utensils, that is where he slipped. You're saying that in that area, there was an uneven mixture of 2 and 3. That's what you're saying.
Yes, Your Honor.
Counsel, I'm sorry. I have an additional question. I've been looking again at your expert's affidavit, and I don't see anywhere that he cites to any specific aspect of the ANSI code or any other code with his claims that the application was violative of industry standards. It just says it violates industry standards. Can you show me anywhere in the expert report where his expert affidavit that actually alleges a violation of a specific standard that anybody goes to?
That finding, Your Honor, goes to basic engineering principles, which is the standard would be the material that's used has to meet a certain DCOF, which
so the thing is he doesn't cite to a specific standard. Is that right?
He cites general engineering principles, not an industrial code standard.
No. So you're saying it's a general engineering principle that it's not adopted by any code that is adopted by any government or any engineering body, correct?
Not that I'm aware of at this time, Your Honor. But what I would submit is, again, on the evidence, on the testimony, their former employee, Ed Cameron, who was brought in as a non-party witness in the related DJ action to this case, testified, this was slippery. We had to tear it out, grind it down, and resurface it. And that testimony was introduced by them on their motion. So that is an admission. If you bring in a former employee, you say, we have a slippery floor, we have to fix it. We had issues with that job, we had to go back and repair it. And you have a record showing that you have different slip resistance on different areas of the floor. A floor that we can't test. And they make a fair amount of Mr. Kensior's affidavit, but he doesn't submit any test results. And how could they claim their floor meets industry standard if the test results are not in? What Dr. Witt has testified to in his affidavit is that the DCOF is not good enough. It should have been 0.43 instead of 0.42. But that's really a secondary issue. The initial, as a matter of summary judgment, if they have not submitted any test results, they cannot rely on that expert's affidavit. And all they've submitted are deposition testimony from the plaintiff and from the non-party witness who said this floor was dangerous at the time it was put in. It was slippery. It had to be resurfaced. I fell immediately. I heard someone else fell. That is hearsay, but hearsay for limited purposes is admissible on summary judgment. And I would submit that based on that, there are questions of fact, more than sufficient for the lower court to have denied summary judgment.
Thank you.
Thank you, Your Honor.
Your Honor, for reply, am I?
Yes, Mr. Sina?
Yes. Just to make sure we're clear, plaintiff seems to be confused of the record. In page 656, Mr. Cameron testified texture 3 had been applied at the ice machine and the rest of the entire space was texture 2. And it's also clear plaintiff did not fall by the ice machine. He fell by the dishwasher. He's never even mentioned anything about an ice machine. So so that takes care of that. With respect to, even if there was a combination of texture 2 and texture 3, there's no substance that they can't be combined together. And there's no foundation to say that that somehow made a slippery condition at all. And as the court, as Justice Gesmore correctly noted, there is no violation of any ANSI standard. The ANSI standard talks about a floor should be 0.42 or above to be acceptable. If 0.42 to be acceptable, that's on a wet floor. This was a dry floor, as claimed by the plaintiff, which everyone acknowledges you would have even higher results. And then what our expert, he corrected the mistake because the results were 0.46. But I don't want to get into a debate on 1/100th of a point. The fact of the matter, the ANSI standard was deemed acceptable on a wet floor, and this is dry, which would be even better.
Thank you.
Thank you.
Mr. Weinberg?
Yes, Your Honors. So what plaintiff did in his oral argument is what they've done in their brief, which is lump Surfaces and Stonehard together and talk about their employee, which Mr. Cameron was not our employee. I just want to focus on this one quote from Mr. Cameron. Question, so as far as you're concerned, they, Surfaces, applied the textures as they were directed. Answer right. And that's at page 662 of the record. Plaintiff's complaints really have nothing to do with Surfaces' work, which was done at the direction and with the acceptance of Stonehard. And to that extent, as I said before, Surfaces should be granted summary judgment in addition to all the points raised by Mr. Cena with regard to the proper nature of the floor itself. So if the court has no other questions, we'll rest on our brief.
Thank you. Thank you all.
Thank you.
Next case is, for argument, is Deutsche Bank National Trust Company versus Godfred Afram. I think it's
Yes, Your Honor.
Mr. Caracciolo.
Thank you, Your Honor. John Caracciolo for the appellant Afram. Since I have only 5 minutes, I would like to attempt to be very brief. First, Mr. Afram's appeal is proper and timely. He is appealing the granting of a judgment of foreclosure and sale, also the denial of his cross motion. Therefore, an appeal of the interlocutory orders is included in the appeal of the final judgment. And his cross motion was based on CPLR seeking vacature of CPLR 5015A3, which had not been litigated before. Further, all exhibits, especially the affidavits, which are included in the record, were submitted either by the plaintiff or by Mr. Afram, by plaintiff in support of its motion for a judgment of foreclosure and sale, the same affidavits, or they were submitted in support of Mr. Afram's cross motion. Second, what we see here is a violation of Rap Apple 1304. This was a home loan under the statute. Mr. Afram pled violation of that statute in his answer. Plaintiff also pled compliance with the statute in its complaint. Further, Judge Elizabeth Gonzalez issued an order denying the first motion for summary judgment. Thus, the burden upon plaintiff to prove compliance with Rap Apple 1304 attached and became the law of the case.
Judge Kern, why wasn't the Magdaleno affidavit sufficient to establish compliance with 1304?
Oh, Your Honor, for a number of reasons. First of all, she submitted no business records whatsoever showing compliance with Rap Apple 1304. The USPS receipts were, for example, blank. No business records were submitted in order to show standing, in order to show compliance with the Rap Apple 1304, in order to prove a prima facie case. I don't understand for the life of me how a plaintiff can claim to qualify for the business records exception to the hearsay rule of evidence while submitting no business records whatsoever. That's really it in a nutshell. Your Honor, no business records whatsoever.
Wasn't it sufficient that she stated her familiarity with the business records and her job and her opportunity to review all these records? She put that pretty clearly to her affidavit, Ms. Magdalena.
No, it's not. And in the Gould case, for example, which this court has ruled on, no, a copy of those records must be submitted to the court. It's not enough. They're unsubstantiated. They have not made their case. They have failed to submit business records and or receipts in support of that affidavit. No proper evidentiary foundation has been laid. They have not made that point. Further, the 1304 notice, Your Honor, violated the statute on its face. I list this in seriatim in my reply brief. For example, it didn't have the correct typeface. The mailing was not correct. It was addressed to two people, and they included extraneous matter in their notice in violation of the statute, violating the statute on its face. And then with regard to the evidence, as I said before, they haven't shown standing. They haven't shown compliance with Rap Apple 1304. They haven't shown a prima facie case.
Well,
Why?
I wonder why do you say that they haven't shown standing? I mean, they attached an assignment of mortgage, and what is it that they haven't shown in terms of the standing?
Well, first of all, Your Honor, that allonge and note was not attached to the summons and complaint. They did not prove standing that way. They didn't do it by means of an assignment. The assignment was forged. The signature was forged, if you'll look at it. It was signed by Betsy Osterman instead of Elizabeth A. Osterman. So what they had to show was receipt of a note before commencement of the action. So they submitted this note, and it appears that the allonge, the endorsement, is on a separate page. They're claiming that it was not on a separate page. Well, they didn't authenticate the note. To my knowledge, authentication requires inspection by an attorney and a statement by an attorney to show that the copy that they submitted matches the original. They never authenticated the note. It was not recorded. Therefore, they did not show standing, Your Honor. Plus, you've got a bunch of sham documents here, or documents just not even signed. You've got an assignment.
This is Justice Gassmer. Could you address your motion to vacate? It appears to me that your sole basis for claiming that you were entitled to vacater of the order was law office failure, and the only thing you said about that was defendant failed to oppose said motion because of law office failure.
Oh, no. No, Your Honor.
Excuse me. That's what your affidavit says. Your affirmation says at page 189 of the record. So I don't understand why that would be an adequate basis for vacater.
No, Your Honor. It was based on 5015A3. I'm turning to page 189. It was based upon the sham or non-existent affidavit submitted by plaintiff throughout the action. For example, the forged assignment, the unsigned trust agreement, the blank postal records regarding 1304, a power of attorney which was never authenticated nor recorded, and a note which was never authenticated. So I've turned to page 189, Your Honor. Can you tell me what paragraph?
Yes, the one, paragraph 20, which says defendant failed to oppose said motion because of law office failure. Right there at the bottom of the page.
That was the second motion for summary judgment. He opposed properly the bank's first motion for summary judgment. He did not oppose the bank's second.
I understand. I'm talking about the motion for vacate for us, in which the only basis you stated to oppose to justify your failure to appear was law office failure.
No, Your Honor, that is not the case. I did so based on CPLR 5015A3, and I did that several times throughout my brief, at the beginning and also in the last section.
But you can't, it has to be based on facts, not only in your brief. I don't see anywhere that's supported factually in your affidavit or in your motion to vacate.
I listed the things. First of all, the plaintiff pled compliance in its complaint with Rap Apple 1304. That was fraudulent. Also, the forged assignment submitted, an unsigned trust agreement, blank receipts for 1304, etc. It goes on, Your Honor.
Are those facts raised in your motion to vacate, counsel? That's what I don't see.
Yes, I raised those facts in the section, in the background section. I pointed all that out, Your Honor.
Any questions? Any further questions from the panel? All right, Mr. Maniello.
Good morning, Your Honors. May it please the court. Yes, there are significant procedural defects, I believe, with the appellant's case. The initial motion, the motion to renew was granted on default. So we have a finding of standing and we have a finding of compliance with all conditions preceded on default. To say that then this appeal can bring up everything and all of these interlocutory orders, I think the appellant fails in that regard because of that finding on default. So then we had the motion to vacate the default, which was denied and not appealed from. However, the court below again went into the issues of standing and the 1304 notice at length, and then we had the cross motion. So this is the order on appeal would be the appellant's third bite at the apple on these issues. As the court brought up the 5015A3 argument, that argument is for a fraud in a party obtaining an order on or judgment, meaning they lied to their adversary about an adjournment, that they surreptitiously went to the court and obtained an order. It doesn't mean fraudulent allegations in prior proceedings. And to argue that an allegation that there was compliance is fraudulent is a leap. We believe the 1304 notice was proper. The business records submitted were proper. There was a copy of the notice, which is in itself a business record. So if the appellant is arguing that the plaintiff concocted these writings, a letter, postal, not a receipt from the post office, but a postal record, which has certified mailing numbers on it and indicates that there were two separate notices prepared. That goes to the certified mailing. The witness testified as to the other procedures that first-class mail was done. Typically, there aren't receipts of a first-class mailing. So when taken in their entirety, it demonstrates that this act, which the plaintiff says occurred, the mailing, did occur. If not, to use the appellant's argument, all of these records were concocted post-sending in order for the plaintiff to prove the case. That's just not credible. On the issue of standing, as the courts acknowledged, there was a note that was properly endorsed. The lower court found that it was properly endorsed. There was a specific affidavit. It was my affirmation also that I had the note in my possession when that motion to renew was made, and that it was the note was reviewed and the pages were flipped, and we indicated to the court below, because the court did have a concern on the initial application. Is this on us? Is this endorsement, not an allonge, is this endorsement on a separate page? And we demonstrated to the court, no, here's the note. It's 3 sheets of paper. It's front and back. This is the first sheet. This is the second sheet. There was particularity in that pleading and demonstration. And then we have the assignment of mortgage. While this court and the Court of Appeals has specifically delved into this issue several times as far as what you need to assign, and there are several defective assignments of mortgage that are shown where it just assigns the mortgage. Here we have an assignment of mortgage, and the language in the assignment specifically said that it assigned the note and the monies to be due thereon. And that was done 5 years and recorded with the recorder's office 5 years before this action was commenced. So I think the plaintiff has met its burden, did meet its burden on summary judgment, and did meet its burden on the judgment of foreclosure and sale. Thank you. Unless the court has any questions, I would rest.
Mr. Caragiolo, you have 1 minute.
Thank you, Judge. This is not merely an appeal of a final judgment. This is also an appeal of that first order which denied plaintiff's summary judgment, but failed to grant the defendant reverse summary judgment. The burden had attached to prove compliance with 1304 and to prove standing. If the plaintiff could not do so, the case should have been dismissed right then and there. That's according to the Silverberg decision in the Second Department, admittedly, and the Weisblum decision in the Second Department, admittedly.
Are you talking about Judge Lisbeth Gonzalez's original motion?
Yes, I am.
How can you be bringing that up now? I mean, everything doesn't come up in a final judgment from years before, and there have been subsequent motions based on that. I don't think that's
Isn't it based? Isn't the final judgment based on the interlocutory orders, Your Honor?
But I think your time to appeal those issues has expired.
I do not believe so, Your Honor. I believe the case law is here, such as in the Aho case in the Second Department. The interlocutory orders, they funnel into the appeal of the final judgment. I believe that is good law. And and those burdens had attached to the plaintiff, and plaintiff failed to meet the burden. The 1304 notice is addressed to two people simultaneously. And as Judge Quinlan said in the Jimenez case in which I was involved, in a day and age when 50% or more of spouses end their marriages in divorce, how can you expect one notice addressed to two people to go properly to each of them? That's not reasonable. First of all, and also the typeface in this notice was less than 14-point type in violation of the statute. That's to begin with. Also, at that point, standing was not proved. The burden was there according to the Silverberg decision. The case should have been dismissed. Judge Gonzalez instead put the burden on the defendant to disprove standing when the burden was in fact on plaintiff to prove standing per the Silverberg decision. And having said that, thank you for your time, Your Honor. I will rest on the brief.
Thank you. Thank you both.
Thank you. Good morning.
Next case is People versus Joseph Ferrigno and People versus Aaron Wickham. Mr. Michel.
Good morning. Good morning, Your Honor. It's Richard Michel.
You may begin.
Thank you, Your Honor. Good morning. May it please the court. My name is Richard Michel. I represent the defendant, Joseph Ferrigno. And with me is David Tauger, who represents Mr. Wycombe. As I said earlier, Your Honor, I'll be doing the main argument, and Mr. Tauger.
Yes, do the rebuttal. I understand.
On this appeal, we raise one concrete issue, namely that the defendant's federally and state guaranteed rights to a fair trial and the right to present a defense were violated by the court's rulings or the limitations placed by the trial court on the cross-examination, particularly of People's witness Zoltan Kovacs, who was a partner in the real estate transaction, which was the subject matter for prosecution, as well as a civil action between the complainant in this case, who brought a declaratory judgment action against the Kovacs brothers, including Zoltan and Peter Kovacs. And what the defense was trying to do at the trial was to establish that through.
Counsel, this is Judge Kern. Why wasn't that questioning collateral? And why didn't the judge then have the right to do a balancing test and balancing the relevancy versus the prejudice, make a decision one way or another not to allow it? Because what did it ultimately have to do with the case that was before the jury in your manner?
Your Honor, most respectfully, it had everything to do with it. And I'll explain to you why. The two bases why the court ruled against Mr. Tauger and against the defendants on this was that the defense that was being presented, mind you, it was an integrated whole. That Mr. Weiss, the complainant, was trying to move everybody else out of the transaction and take it for himself. And the first step in doing that was to pay off the defendants to get them out of the case, to give them back what Mr. Weiss referred to as their skin in the transaction.
Counsel, if I may, this is Judge Reinhold. On the initial issue, within the trial, this trial itself, the
Correct.
Jury would have been able to determine the credibility of Mr. Weiss versus the defendants about whether, in fact, there was a secret deal made to the defendants or not. So now you were going into the next to the civil trial, where the court said, in questioning Mr. Weiss and the Kovacs, you could ask them certain questions, but not with regard to, I think you were stopped where it was a question of whether or not a promise had been made by Mr. Weiss to the Kovacs brothers and reneged. That aspect was not permitted, but you were able to ask about the friendship that they had between them. There were other questions you were able to ask. The court stopped, as my colleague said, because that was going to go so far into a collateral attack on a witness that the court doesn't usually allow such collateral attacks that are twice removed almost in this instance. So
If I may, it was a multifaceted approach. What the defense was trying to establish through the cross-examination of Zoltan Kovacs is that, and this was stopped also, that Mr. Weiss approached Kovacs and said, let's do the deal between us and let's get the other two guys out of the case. That was not permitted before the jury either.
So how does the issue, though, of whether or not the Kovacs would be personally liable for the payment of the loan interplay with your whole theory of a secret deal? Why is that so relevant to your theory that there was a secret deal?
That was, Your Honor, that what we're focusing on right now was not the be-all and end-all of the cross-examination. The purpose of the cross-examination was to establish that Weiss had this secret plan to take over the entire operation, to get Kovacs out of the project and get the defendants out of the project. And the first step in doing that was he had to eliminate what he called at 95 and 96 of the transcript, the skin that they put into the transaction. The jury would not have understood. It would have been totally inexplicable if all that they had before them was that Weiss suddenly just gave them back $1.236 million so that they could go off on a frolic and detour and do whatever they wanted. They would never understand what, it would make no sense for him to do that when all of the written agreements, Your Honor, and all of the testimony was that Weiss was doing everything he could to protect his investment at the expense of the defendants. This was a secret prop, and it only makes sense, Your Honor, because look at this transaction. This transaction occurs in a month's period of time. They meet in April. 10 days later, they've got a term sheet, and 3 weeks later, there's a closing. And Weiss has gone from a $5 million investor with no equity to 20% equity to, on the day of the closing, 33% equity. And the fact that the defendants did not see this coming, that they were being moved out of the transaction, was really to Weiss's credit, his business acumen, that he saw these two farmers coming to him and he was taking advantage of them, that they did not see exactly what he was doing. And they needed the cash so bad, they grabbed the cash. But the point is that the whole transaction, it was necessary to point out, it was necessary for the jury to understand that what was going on here.
Look, I go back to what,
you go ahead.
I go back to what Judge Kern asked at the beginning. I mean, didn't the judge, understanding that that was your point, because that was your defense, at least part of your defense, weighed the probative value and the prejudice and allowed certain testimony in, but felt some of the testimony, the cross-examination that you wanted from Kovacs went above and beyond, and he wouldn't be able to answer it. So what did the judge not allow in? I mean, where was the mistake that the judge made? Because I thought that the judge weighed this pretty well and allowing some things in, but stopping it before it got so confusing and so collateral that it went, off the reservation there. So I don't see what the judge did wrong here.
All right, Your Honor, if I may, the judge's approach to this was twofold. Number one was he said that there was no basis in the record, in the evidence, to go with that defense. And the second thing was he looked at the defense as a two-part defense. We're arguing that it naturally flowed from the evidence, number one, and number two, that it was part and parcel of an integrated whole. I will tell you—
What did Judge Marchand not permit?
He did not permit, Your Honor, most respectfully, he did not permit the defense to go into the fact that Weiss's intention was to get them out of the transaction by merely giving them back their skin. The jury doesn't understand why they're getting their investment back. There would be no reason, no explanation for Weiss to give them back their initial investment unless they understood that Weiss was making a play on the whole project to get everybody. This was a project that he originally thought was overpriced, and he came to learn was worth $38 million. He's increasing at everybody else's cost his stake, while everybody else's stake is being reduced. He is not increasing his investment. He is getting more than what he invested for. The only way the jury understands this, Your Honor, is that if they understand that he is looking to move everybody out, so when it comes time for the project to end and he's selling off the project, he's dividing the profits with nobody. Up until the cross-examination of Kovacs, none of this is before the jury. This is the whole defense. You know, the prosecutor argues about the overwhelming nature of this evidence, and this is a mid-trial conjuring. The whole point of this evidence was, yeah, the evidence was overwhelming, but if without this evidence was the only way these defendants was going to dig out from underneath this mountain of evidence, these documents, and this testimony. It was their only defense to the allegation that they stole $880,000. And this was not a mid-trial conjuring, Your Honor. This was from the very beginning what was being argued by the defense. Look at the opening statements at pages 35 to 41. It's in our reply brief. He specifically says that what Weiss is looking to do is take over the whole thing. Yet mid-trial, when it became obvious that Weiss's credit.
This is not a question of whether it came up in the beginning or whether it was mid-trial. The court was trying to balance what was there. There was other testimony that, in any case, I'm going to stop there. You can think about that. Your other co-counsel will do rebuttal. Let's move on to the people. Brent Ferguson, I believe it is.
Yes, thank you, Your Honor. Brent Ferguson for the people, and may it please the court. Your Honors, the trial court was correct here. There is no probative value to the evidence at issue.
Well, I don't know if there's no probative value, Mr. Ferguson. You know, what they're saying is they were set up that, and this is their defense, right? So defendants should be able to, they have a right to present a defense, right? And so they're saying that this guy was setting them up, and he's flip-flopping on what he says for his own convenience. He told them, hey, secret deal, and then he pulled back, you know, and is now saying they stole money. And they're saying that if they were able to show that Kovacs and he had the same sort of situation, he said that they didn't have to pay him back, and all of a sudden Kovacs now has to pay him back, and all of these other things that would have been reflective of his credibility, of Weiss's credibility. So It would have gone to the jury understanding that. So it's not irrelevant. It's not probative, but there were other considerations. Why don't you tell us about those?
Sure, Your Honor. Well, I'd like to focus first on just getting the terms of this deal straight and why we're arguing that there was very little probative value here, and why the argument of the takeover is unrelated to the only defense that the defendants put forward. So Weiss gave a $4 million loan as part of this project, and a key term of that loan is that Weiss gets to take over the whole company if they don't replace his money within 6 months. They're supposed to find a longer term loan, and they've promised him they've already set that up. Now, the defense, though, is that there's a secret agreement at the closing table on May 20th that he's reimbursing their capital contribution with part of his loan. Of course, then they immediately steal $880,000. Now, the problem with the defense and the probative value here is that even if it was true that Weiss had this plan to take over the company, he didn't need to reimburse the money. And that's really the central issue that we hit at trial and Justice Merchan agreed, and that we've hit on appeal. And the defendants have never answered this. So by the terms of the agreement, and that's the contracts, the testimony supports this, and defendants' own text messages, the only thing that has to happen in order for Weiss to take over this deal himself is that the $4 million is not repaid within 6 months. He doesn't need to repay their $1.225 million. And that's something the defense just argued right now. He needed to get their skin out of the game. He needed to claim they didn't put any money in, but that was not necessary. That's something we brought up at trial, we brought up at appeal, and the defendants have never pointed to one single piece of evidence that would support that idea. So that's extremely important. Now I'll move on, Your Honor, to the general credibility point about if Weiss was dishonest with Kovacs, maybe that helps them prove he's dishonest here. First of all, I don't think that defendants have argued that directly on appeal. They've focused on this issue that I just discussed, the relevance. And so I would argue that's abandoned. Second, it's only very minor with regard to credibility. This court has said that if it's an issue that has little probative value on the defendant's guilt specifically, then it still doesn't come in, even if it has some minor weight as to general credibility. That certainly wasn't enough here. And I would say we also have to add in the mix what the trial court looked at is the confusing nature of this evidence. So I want to go through what the jury would have had to do if they heard this detailed evidence. They would have first had to hear details about a civil lawsuit between Weiss and Kovacs, this third party. Then they would have had to decide if Kovacs was correct in that lawsuit, arguing that Weiss set such prohibitive economic terms that they wouldn't be able to get a new loan to replace Weiss's $4 million, and then that would help prove that Weiss wanted to take over the deal. So as you can tell from my explanation, that's rather complex, and it's just the jury's just not equipped to make that decision. And when there's such minimal probative value here, and it has such a tendency to confuse the jury, it simply can't come in. And it was the correct decision, and it certainly wasn't an abuse of discretion. So if you'll allow me just for 1 minute, I'll address the harmlessness here, because even if there was some probative value here, the evidence was absolutely overwhelming that defendants knew that they weren't allowed to use this money, and they did it anyway. The first and most obvious reason is that the whole defense was that Weiss created this secret deal on May 20th at the closing table, but the evidence showed unequivocally that the defendants 2 days earlier were already planning on using Weiss's money to repay their creditors. So it doesn't make any sense that Weiss would have said this deal 2 days after they had already agreed to spend the money. They also, after the closing, agreed to pay some of the bills with the money they got. They were hiding their theft, and they pretended like they were using the money for the project. And that's extremely important, because if they thought the money was their own, there's no reason that they would have been using some of it for the joint project. And of course, when they were caught and Kovacs confronted them about the theft, they didn't say it was our money. They said, we'll try to replace the money. We just had to use it because there was a deal we couldn't pass up. So, Your Honors, for all of those reasons, the trial court was correct and any error was harmless. And I'd be happy to also address the sentencing issue if you'd like to hear about it.
Thank you. I think we have no further questions. By Mr. Tauger?
Thank you, Your Honor. I want to go back to your original questions. The question, the most important question, what everything was leading up to a trial, was the question to Mr. Kovacs, isn't it true that Mr. Weiss said to you, let's get rid of Wickham and Ferrigno? That's the question the court didn't let in. And that's the most important question in the whole trial, because that proves everything else is relative. That question was not allowed by the court. We brought it up in our brief at page 38, and that's what was the heart of the defense. If Weiss says that to Kovacs, that proves that he was trying to take the project away from him and trying to set it up so he would be in charge. Everything flows from that question. Without that question, and it's no doubt that that was, Kovacs would have answered that question. Yes, he said that to me because he made a sworn statement in the civil lawsuit. The civil lawsuit is not relevant. You're right, it's not relevant. It's very tangentially relevant about who's going to end up paying for this. But what was very relevant was that Weiss said to Kovacs at the beginning of this deal, let's get rid of Ferrigno, let's get rid of Wickham and take this project for ourselves. And that's what's important. And Weiss does this. This is a very experienced businessman who as it came out in trial, there are banks all over the place. He was the one that was responsible for opening up the bank account for the LLC that was created.
Can I ask you a question? Isn't there still a problem that that right immediately after the closing that the defendants took hundreds of thousands of dollars that was put in by Mr. Weiss and it was used for the California projects and for other projects? I mean, how do you get by that, even if there was some kind of an agreement? I don't get that.
Because that's not Weiss's money anymore. That's Weiss is giving them their money back. That's their money now. They can use it any way they want. It doesn't matter how they use it. They can use it any way they want. Weiss
but there was more money. I thought he gave much more money than just that amount.
He gave 1.2 million. They $880,000 to pay off their own debts, but they didn't know that they were getting wiped out of the project. So they wanted to get the project to keep moving. So they used some of that money to get the project to keep moving. But what's important to note, Your Honor, is that Weiss is the one who controlled the money. And the deal said the money had to go to the bank account opened by the LLC. And he violates that rule. He breaks the agreement right there and sends the money directly to the Mavericks' personal bank account. And then what he does know, and what we brought out at trial, was there was no way that they were going to get the variance that made this project worth the $38 million in 6 months. Weiss knew from the moment he gave them the money that this project was going to fail, because there's no way in New York City that you're going to get a variance to build this project in 6 months. Everybody answered that question that way during the trial. Everybody knew that except the two guys from San Diego who don't know anything about New York. And that's why they got Weiss into this to begin with, to help them out with how you invest in New York. And so what Weiss does is he sees this project for a $38 million project. He sees two guys from San Diego he can take advantage of. He does that. And then when the project, 2 days before the project's going to take place, he says to Kovacs, let's get rid of them and do it ourselves. And the way to get rid of them, the reason why it's most important, as the district attorney argued before, why does he have to give them their money back? He has to give them their money back because the court is going to, if there's a lawsuit later on, the court's going to look and say, well, they put in $1 million. That's their money. You didn't give that back to them. And now he has. He's given that back to them. So it makes it clean. It makes it a very clean deal. He knows it's going to fail. He's wiped out their investment in the project. And he knows that Kovacs is not going to be doing any building, so they're not going to have any sweat equity. There was nothing to build till they got the variance. There's no building. Kovacs does no work on this project in the 6 months, so they weren't going to get any money. It's Weiss's way of taking $38 million and putting it in his pocket, which is exactly what he did in his past in Texas and other places. But the important question, to get back to the original questions that you all had during the original argument, the important question that Judge Mershon didn't let in was, Mr. Kovacs, didn't Mr. Weiss say to you, let's get rid of Wickham and Ferrigno? That's the one question we needed. That was the one question we needed. And the minute Judge Mershon said, you can't have that question, is the minute I said to the judge, you're taking away my defense. It wasn't the question about the promissory notes and taking over the project. The question, the important question, where this whole case hinges on is what was Weiss's intentions? And Weiss's intentions on the day of closing is that statement to Kovacs, let's get rid of Ferrigno and Wickham.
Any further questions from the bench? Thank you, Mr. Michel.
Thank you.
Thank you all.
Thank you, Your Honor.
Next case is Empire Center versus NYPD Pension.
Good morning, Your Honor.
Good morning, Mr. McDonald. You may begin.
Good morning, Cameron McDonald, Government Justice Center for the appellant and cross-appellant respondent, cross-appeal respondent, Empire Center for Public Policy. I want to start out today, if it pleases the court, by getting back to an issue that is easy to forget from law school, which is what res judicata means and its elements. I think we get practicing law and forget that there's two elements to res judicata: claim preclusion and issue preclusion. Claim preclusion happens when there's an event and there's a lawsuit and a litigation and a finality to a particular event. Whereas issue preclusion, there is a different event but has the same facts and law and is precluded on that basis. What we're talking about here and what this appeal is based on is the fact that the court relating to Freedom of Information law requests invoked issue preclusion for a different event where there was the same facts but different law. This is part of a decade-long effort to get retiree names from certain pension systems for law enforcement personnel. The claim at issue here is a FOIL request made in 2018 for the retiree names of members of the New York City Police Pension Fund. It came about because after the law changed in 2014, Empire Center made several FOIL requests to different pension funds to get names of retirees after the Court of Appeals had clarified that retiree names could not be withheld on the basis of privacy.
But this time it wasn't done on the basis of privacy. This was a different section, the safety exemption, which was not dealt with in the prior cases. Isn't that true?
Yes, that's true. So,
and the standard there is not quite that high. It says that as long as there is some probability that there could be some safety issue, and they put in a lot of affidavits. The respondents put in a lot of affidavits from various retired detectives and officers explaining why there was a possibility. So how did that not at least comply with the standard that they were required to comply with under this provision of the law?
So it did not, because the court correctly concluded that that what was in the affidavits was speculative. It wasn't connected to retiree names in a database, and that's similar to what the court concluded in 2015 and 2016 in Kings County in Brooklyn. The courts concluded that similar claims by similar pension funds were only putting forward speculative evidence. And it's similar, Your Honor, to 1983 in the New York Veteran Police case, where the Court of Appeals reversed this court on the privacy grounds, but didn't touch this court's holding in that case that the agency had not met its burden to prove the life and safety exception. So what we had here in this case, and the judge
in the veterans case, they didn't deal with this exception that you're talking about. I don't even know if it was at the time for the life and safety. And as my colleague has already indicated, the statute here talks about could, which is just a possibility. So these affidavits here, even though there are a few of the affidavits, doesn't that establish the possibility that the officers' lives can be in danger? I mean, I can see that there are only, I think, maybe 5 affidavits. I'm not even sure how many. That's a small number in terms of how many police officers there might be who are retired who fall into this category. But it's a possibility. Doesn't that establish that?
No, I think No, I think it only establishes, at best, a remote possibility. It doesn't even connect.
Does the statute say remote or otherwise? It said it could be, which is, it's possible.
Yeah, I mean, except that these affidavits are completely speculative. I mean, possible has to connect to what's being sought.
Justice Gessner, yeah.
Given that the standard is could endanger, it seems to me that that really essentially is satisfied by speculation. This is not a standard of proof that's very high. And the cases have held for not just, Bellamy cited many prior cases that said the standard was that the agency must only show a quote unquote possibility of endangerment. And while I agree with you that the affidavits don't show proximate cause, that's not the standard here. And while that could have been the standard, but it's not. The standard is only possibility. So I don't understand why these affidavits aren't enough to establish a possibility of endangerment.
Because none of these affidavits connect in any way to names in a database. So the competing affidavit.
That's necessary if, for example, the standard were probability or proximate cause, but the standard is only possibility. Why does it have to relate back to the specifics of how a specific incident of endangerment occurred?
Well, because then it's just rank speculation, and as we point out, initially the Police Pension Fund raised the issue of Valentin orders in the federal courts, and what that allows is somebody who only knows a little bit or some nickname of a police officer or some portion of their name to actually go and be able to get a police officer's name, an active duty police officer's name, get their information. And those are people who actually have a grudge. All the evidence put forward by the Police Pension Fund was anecdotal stories of people who actually most of the times had connections with the people who were approaching them and threatening them. The counterbalancing.
Didn't the affidavits also talked about incidents where there was violence directed at police officers just by a person who had a generalized grudge towards police officers as opposed to a particular police officer? So doesn't that kind of evidence don't those kinds of stories go to create a possibility of endangerment in this situation?
No, because we're talking about, I mean, those stories go to, and those are unfortunate incidents, but those are uniformed officers on the street who are identifiable as police officers on the street. Those same officers, the New York City publishes their names in its active, and the court noted this. For the last 5 years, New York City has been publishing all those officers' names in its open records database in a spreadsheet that somebody can download, sort, filter, and sift.
Counsel, let me ask you a different question. How do you address, well, I'd like you to address Penal Law Section 400, because it seems to me that provision, by stating that a firearms license can be treated as confidential because the applicant's life or safety may be endangered by disclosure just because the applicant is a retired police officer. Doesn't that constitute a legislative finding that retired police officers have a possibility of being endangered by having their personal information disclosed?
I think, as we argue in our brief, the issue is it's not a guarantee of confidentiality. It's a potential criteria. So it's something that flags it as a reason for that, which may be a factor in that retired police officer's favor. It's not that the legislature is saying it's mandatory. But I do believe that it is something that just allows it to be flagged for the discretion of the decision maker as a mitigating factor.
Okay, any further questions? Thank you. Mr. West? No, I'm sorry, Ms. West.
Good morning, Your Honor. May it
Good
please
morning.
the court, I'm Melanie West, of the New York City Police Pension Fund. Let me just start by addressing the issue that the pension fund is raising an appeal, which is the possibility of endangerment, and then I'll turn quickly to the issue of the duplicativeness of the FOIL requests. Supreme Court here erred in applying the wrong standard for the possibility of endangerment. As this court has noted in its questions, the standard is clear. It was noted by affirmed by this court in Bellamy and by other departments of the Appellate Division as well, that there need only be a possibility of endangerment in order for information to be withheld under the life and safety exemption, and that's amply established on the record here. As an initial matter, Penal Law 400 does indeed essentially equate being a retired police officer with having a risk to life and safety if personal identifying information is published. So while other individuals need to prove that their life and safety would be endangered if their personal information was released in order to avail themselves of the exemption under that statute, retired officers need only show that they are retired police officers in order to avail themselves of the function. So as Justice Gesmer noted, that is indeed a clear signal that the state legislature has found the two things to equate to each other. And in addition, the Police Pension Fund here put in an affidavit evidence about the risks that are faced by police officers from the public, the efforts that the NYPD makes to ensure that personal identifying information is not made public in a way that would allow members of the public to track down police officers, particular incidents against not only active police officers, but against retired police officers as well. Deputy Commissioner Miller's affidavit details 2 incidents where retired police officers were approached following a 2009 disclosure of their names pursuant to a different FOIL request. And additionally, there's an affidavit from the commanding officer of the licensing division, handgun licensing division, explaining that retired police officers are particularly targeted for handgun theft because they're known to have handguns in their homes. And at the same time, retired police officers do not have access to the same level of protections that active police officers do. Many of them don't even live in the city anymore. They don't have the protections that the NYPD is able to offer to its active police officers, so they're particularly at risk. And all that evidence is more than enough to satisfy the possibility of endangerment standard, which is all that's required to withhold this information.
So any other questions?
Your Honor, if I could just very quickly touch on the second point, which is that Empire is appealing from the portion of the court's decision that found that new retirees' information should be released. Or I don't have to address it, actually, unless the court has any questions about it.
Any further questions? Thank you.
Thank you, Your Honor.
Mr. McDonald? Mr. McDonald?
Yes, ma'am.
Okay. I'm sorry, you didn't request any rebuttal, but you didn't use,
I don't think I used I'm not sure if I used my time.
I'll give you 1 minute.
Your Honor, in that case, since there's a cross appeal, could I also have a minute at the end?
I'll give you a minute. Okay, neither one of you asked for it, but I meant to ask you if you wanted it. Okay, go ahead.
I ended before getting to the point that the affidavit evidence from the Empire Center is tens of thousands of retiree law enforcement names have been published over the last several years, with there being no evidence of any reports of violence relating to those names being in a public database. And that's the, I'll submit on the briefs for the remaining.
Okay, thank you. And Ms. West?
Nothing further from me, Your Honor.
Okay, thank you both.
Thank you.
Kasowitz Benson versus.
No, we're doing it the other way.
Oh, I'm sorry. Yes. 111 West 57th Street. 111 West 57th Investment versus 111 57th Property.
Your Honor, this is Stephen Meister for the appellant. Do you hear and see me?
Yes, you may begin.
Okay, if it please the court, Stephen Meister. Thank you, Your Honor. Your Honor, I think we're first dealing with the dismissal order, which was an order dated February 28th, 2020. It appears in record 6 to 9 here. Your Honors, twice before this court, the First Department Appellate Division has recognized that appellant's recourse lies in equity. In a January 17th, 2019 decision, which appears at record 285 to 287 of this appeal, when this court was reviewing Justice Branston's decision in dissolving a TRO in a related case against the strictly foreclosing lender, who I'll call Spruce, this court pointed out that, well, by then, the strict foreclosure had happened. By the time in January of 2019, this decision was before the court, and therefore this court said the complaint should be amended, that there was a live declaratory judgment claim that the strict foreclosure was improper under law and was wrongful.
What we said on that case, I think both myself and, well, no, I guess I was the only one on it. But what we said in that case was that it was moot with regard to the strict foreclosure. The strict foreclosure had already occurred, and you were seeking a preliminary injunction. So we said that was moot. But you would also ask for a declaratory judgment, and we said that that was not moot, and that you might be entitled to damages. That's all we said from the junior lender. And so we allowed it to proceed on that basis.
Justice Renwick, what you said, or what the court said, this is record 286, you said, however, the complaint as currently pleaded mentions neither damages nor a constructive trust. So the court did sua sponte mention a constructive trust, which was nowhere in the pleadings.
When we do that, we're not telling, you can amend however you want. We're just saying that it wasn't something that was raised, and so that you had the option to do what you want. We're not in the position of advising attorneys what to do on their case. So we were not telling you that you had a viable claim one way or another. It was there for you to make the decision.
Your Honor, later on, I think there's a much more compelling decision or order that comes out of the court. On October 10th, 2019, in connection with a motion related to the appeal of the lis pendens cancellation order, in this case, the appeal we're about to argue in a few minutes, a panel of 4 justices, including Justices Kapnick and Kern, presently sitting, issued at our request a 5518, a CPLR 5518 injunction pending the appeal of the lis pendens cancellation order, restraining the sale of the property based on the
Counsel, being on that panel, those are routinely granted just to maintain the status quo. That does not mean that we are ruling on the merits in any way. We are simply saying that based on all the circumstances of this case, we are willing to maintain the status quo until the appeal is before us. So that cannot be used to support the argument on the merits.
Okay, so let me then turn, Your Honors, to the merits. On the constructive trust claim, the lower court's decision here is a simple two-sentence portion of the decision, which says in substance that the court is dismissing the constructive trust claim because it's an equitable remedy and the plaintiff may be made whole by damages. And the court notes that we're seeking damages for our aiding and abetting claim, which is the other claim in this 2-claim complaint. That was error on controlling law. There are many cases, including Homapur versus Harunian, which is a First Department case from this year, reversing a 3211 dismissal of a constructive trust claim, where that claim was joined by a money damages claim based on breach of fiduciary duty, almost identical to this case. There's Klein versus Gutman, referenced in our papers, which is a Second Department decision, so holding. Gerenstein versus Williams, which is a Third Department decision, also allowing a constructive trust claim and a money damages claim. And finally, Schneidman v. Tolman, which is an earlier First Department case from 1993. So we think it was error on controlling law, away from whatever guidance one may draw from the
Counsel, this is just, so is your argument that if your claim is clearly for money damages, it's only a claim for money damages, there's nothing else you're seeking but money damages, you're still entitled to the imposition of a constructive trust? Is that what you're arguing?
I'm arguing that I'm entitled to seek the impression of a constructive trust alongside a claim for money damages for the wrongful strict foreclosure, because the underlying asset that was lost in the strict foreclosure was real estate. And
but counsel, this goes to the lis pendens, right, which is the same exact issue here. You're not ultimately seeking an interest in the real property. You had a money interest in the joint venture, which could be 100% compensated by money damages. So that goes back to my last question. If there's clear 100% in this case, if the only thing you would ultimately be entitled to is money damages, are you still arguing that somehow you would be entitled to a constructive trust?
Yes, I am arguing that I would be entitled to a constructive trust. The Court of Appeals has written that, in the words of Justice Cardozo, and this is from the Simmons versus Simmons case, a constructive trust is the formula through which the conscience of equity finds expression when property has been acquired in such circumstances.
Did you have any title? Do you have any title in the property? I mean, you have no interest in the property itself. You have equity interest. You have equity interest in a company, shares in a company which has a proprietary interest. You don't have any, any actual possessory interest in that property.
We don't have title to the property, but I think the controlling law is crystal clear that if the circumstances are such that it would be inequitable for the defendant to hold title to the property, I can seek the impression of a constructive trust. And frankly, the injunction pending appeal was to maintain the status quo, but under controlling law, when a 5518 injunction pending appeals issued by the Appellate Division, there is the three-prong test, including likelihood of success and the merits. So I do think that there was a prior, I don't think it's binding because it was a provisional remedy, but I do think that this court did consider that. And
Mr. Meister, I was also on that panel, and I agree with what Judge Kern said before. I mean, when we do these, we take a look and we say, well, the appeal is coming up to maintain the status quo. Let's keep things status quo for this short period of time. However, your argument seems to be, and I think these are interrelated, these two appeals, obviously, is that you're seeming to argue in some way that you actually have more of an interest in the real property than you really have. I mean, you don't have an interest. I mean, that's what Judge Sherwood found below, and that's why he that's why he denied, or that's why he directed your lease pendants be vacated, because he didn't find that you had a property right. It was really a personal right, and it all comes down to money damages. And I don't see how, even though you may have disputes, that the connection that you have is just a little too attenuated to be a property interest in this deal.
Well, I would respectfully disagree, Justice Kapnick. I think here we were the largest partner, $70 million, it's true that we had an equity interest in an entity that ultimately owned the real property, but this is unique real property, and we're not specifying.
Everything's unique real property. That's
what makes this.
Well, this is as tall as the Empire State Building. It's billed as the slenderest tower in the world. It overlooks Central Park. It really is an extraordinary property, and we were the largest partner in the property. And in the absence, I'm sorry.
It seems to me that you just conceded that you don't have an interest in real property. If you prevail, the entity which owns title would not change. All it would change is the parties who have an interest in the owner of the real property. So if the title wouldn't change if you prevailed, then you don't have an interest in real property, and that, it seems to me, destroys your claim to the Liz pendants and also your entire. So do you agree that if you prevailed, title to property wouldn't? It seems to me that you conceded that if you prevailed, title to the real property wouldn't change. Is that?
I don't. No, I don't agree with that, because the judgment that I'm demanding does affect.
Wait.
Prevailed. How would title change?
Justice Ginsburg, it's a little difficult to hear you, so that's why the council keeps speaking. If you would speak closer to the mic.
Right. How would title change if you prevailed?
Justice Ginsburg, sorry, I didn't mean to speak over you. I thought you had stopped. The title would change, and this is very clear black letter law, because although the titular owner of the title would not change, that titular owner's title would be held pursuant to an order impressing a constructive trust over that titular owner's possession of title. That does affect title. That is a judgment demanded that affects title. There's no question about this. Cases are legion, including, we're kind of bleeding into the other appeal. But
why don't you argue the other appeal now, rather than us having to split? You're both the same counsel.
Okay, fair enough. Give me just 1 second to get my notes on that appeal. Okay, so under 5303 Realty versus O&Y, which I think is the leading case in this area of list pendants, it's very clear that when a court is reviewing a motion to cancel a list pendants, it doesn't. It's limited to the four corners of the complaint, and it doesn't look at the merits of the claim. It's also very clear that the issue is, does the judgment demand it? That's the phrase from 6501. Does the judgment demanded affect real property? Not, does the plaintiff presently own, or does the plaintiff seek by the judgment it seeks to become the owner of real property? A mortgage foreclosure action always takes a list pendants. The plaintiff is seeking money, but the relief demanded affects real title. Here,
counsel, the plaintiff isn't seeking money. The plaintiff's seeking to foreclose on the real property. That analogy makes zero sense.
Here, Justice Kern, the plaintiff is seeking to impress a constructive trust. This is a 3211 motion.
Counsel, I'm sorry. Your argument seems very circular to me, because you keep arguing that if you get a constructive trust, it will then affect the real property. But you can't get a constructive trust unless you have an interest in real property. So the mere seeking of the constructive trust cannot be the linchpin of your claim that it affects real property. It has to be that you have some interest in the real property. And there's clearly case law out there that an interest in a joint venture in real property is not an interest in real property. So if you don't have any interest in real property, how can you get a lis pendens or a constructive trust?
Your Honor, with respect, I don't think that's an accurate statement of the law. You can there's no question about this. You can seek the impression of constructive trust even where you don't own or seek to own an interest in real property. This court, for example, in Don v. Singer, held that that the seeking of a constructive trust supported the list pendants. And in Herman v. Herman, which is probably the single most on-point case to the point you're making, Justice Kern, what happened there is that there was a trust that owned an equity interest, very similar to the equity interest that my client owns now. And Justice Kornreich, who was the trial judge in that case, it was a 2014 decision, canceled the list pendants because of exactly what you're saying, that the plaintiff did not own or even seek to own a constructive trust. This court reversed in a 2015 decision. It is a brief decision, but it was unanimously reversed, and the court simply said in their complaint, plaintiffs seek, among other things, the conveyance of title to real property. Well, they seek the impression of a constructive trust over real property. So if I seek the impression of a constructive trust because the circumstances are that it would be grossly inequitable given the corrupt underlying strict foreclosure for which a bribe was paid, then the titular owner becomes a trustee ex maleficio by virtue of the order impressing a constructive trust. That affects title, and therefore 6501 is satisfied. Therefore, Justice Sherwood made an error in dismissing the, in dissolving or canceling the list pendants. And in terms of going back, because we're kind of arguing both, this dismissal, this is a 3211 motion. There is a incredibly developed record of extreme wrongdoing here, where a bribe is paid to consent to an extraordinary remedy, which is a strict foreclosure, not the normal foreclosure sale. And the evidence is very clear that the bribe was paid and that that Stern and Maloney are back in the deal. By the way, there's an aiding and abetting claim in here. What was missed there, if I could just say briefly, is that Stern and Maloney got two things. They got back into the deal on the equity side. That's not a titular interest, but they were promised and did get paid millions of dollars of construction management fees by the property owning entity, which is the respondent here, and of course the defendant on the constructive trust claim. So there's no question that the property owner aided and abetted the breach of fiduciary duty by agreeing to and in fact paying those construction management fees. So
any other questions by the panel? No? Okay, thank you, sir. Mr. O'Connor?
Thank you. Good morning. It still is morning. I'd like to pick up with the, if I could, just briefly with the what counsel for respondent was talking about, the Herman v. Herman case. It's sort of the list pendants piece, but then I'll go right to the motion to dismiss. But with all due respect, that what was said about Herman versus Herman is incorrect. In that complaint, the defendants were alleging that they were deprived of trust of title to the property, and they sought transfer of title of the property to the trust. It was directly about real estate and the transfer of title to the trust. This is, as all of your honors have recognized, this is not a case about real property ownership interest. This is an LLC interest. And now I'll switch kind of quickly back to the motion to dismiss. I mean, the fact of the matter here, and you have to start with this, which is that the respondent here, the property owner, is being sued by an LLC owner way up the chain. And I would turn the court's attention to page 22 of the record, which is the paragraphs 42 and 43 of the complaint, which shows quite clearly where this appellant now, which is investments, stands in relationship to the defendant here, the property owner. And if you could see that, if you had it in front of you, you'd see lots of boxes and lots of lines But they obviously they are not an owner of real property. The case law is clear. We've cited it in our motion to dismiss and on our list pendants papers. And Justice Sherwood recognized it literally within about 2.5 seconds of the oral argument on our motion on the list pendants, that having an LLC interest in an entity that may have an indirect ownership interest in real estate does not give that LLC member an ownership interest in the underlying property, be it real estate, stocks, whatever it is. It gives you an interest in that LLC. And if there's been something done wrong in that LLC, and I will say this, the AmBase has gone after just about everybody connected with this project. They have at least 4 lawsuits pending. Some of those lawsuits have been amended 3-4 times.
Excuse me, is AmBase the parent company or somehow connected to the plaintiff? What's the connection with the plaintiff?
They owned AmBase.
That's right. AmBase is connected with investments. I'm sorry, Your Honor. But the real point here is that this is just sort of a house of cards. I mean, this is a 4th lawsuit, 3 others in which they're seeking money damages from defendants who they alleged were part of this outrageous scam that they claim was pulled off, for which they have no evidence. But they're suing all sorts of folks for money damages.
Let's just stick to this one. Let's just stick to this one.
Let me get right to it. As for there's really only one claim here, because as was recognized earlier by this court this year in the Hamapur case, a constructive trust is not a claim, it's a remedy. It would be a remedy here for an aiding and abetting claim. And we're alleged to have aided and abetted a breach of fiduciary duty. This complaint, all 150 counts of it, alleges almost nothing against respondent, as was recognized by Justice Sherwood. Much less anything that is alleged against us could not possibly have caused the alleged breach of fiduciary duty, because what we allegedly did happened afterwards. And, you know, again, the question isn't whether we were involved in proximately causing it. We had to substantially assist it. And all that's alleged, and here you have the assistance not only of the complaint, but of their reply brief for you on this appeal, where they note at page 6 that the real beef against respondent is at pages 40 and 41 of the record, which is the complaint, which is, excuse me, I've gone to the wrong page. Excuse me, page 34 and 35 of the complaint, where you'll see what the defendant, what the respondent here is alleged to have done is signed some bank papers and some tax papers and some permits in late 2017 and in the middle of 2018. That's almost a year after the strict foreclosure took place. The alleged wrongdoing is that there was not the respondent here, but the 2 other individuals allegedly did not object to the strict foreclosure. I could go into the reasons that they didn't do it, but I take the stricture to stick to this case. And then there was a strict foreclosure in August of 2017. Everything in this complaint that the respondent allegedly did happened after that. It cannot. We cited a long line of cases in here which point out that approximate cause has to happen in the time period where the wrong was being caused. It happened in July and August, if it happened at all. What's alleged against the respondent here happened much later. And again, it was simply, as was noted by Justice Sherwood, it was routine actions. It was signing tax documents, signing permits for a building that's going up under construction. You can't. So
is your argument that if there was no aiding and abetting of any breach of fiduciary of the non-party individuals, because there was no action on the respondent's part, then if that didn't exist, then there can be no a remedy of a constructive trust, and that's the end of that case.
Exactly, Justice Kapnick. That's exactly what I'm saying, and I should have gotten there more quickly. But yes,
it helps understand. That's your argument.
Yeah, without an underlying claim, this is a remedy, and this court, recognized it. They've recognized it many times, but they just happened to have recognized it very earlier this year in April in the Hamapur case, which states clearly this is a remedy, and if you don't have a cause of action, you can't get a remedy. You can't get money damages, and you can't get a constructive trust. Now, there are other reasons that Justice Sherwood didn't need to get to. that also would preclude a constructive trust here. That even if there was a claim, which there isn't, in order to plead a constructive trust, you have to plead a fiduciary or confidential relationship. None exists here. The Simmons case, which counsel for appellant cited, actually deals with a husband and wife who obviously have a fiduciary or confidential relationship. There's zero relationship here between investment and property owner. Second, you have to have an interest in the property, and we've gone over that. And again, I pointed out that the section of the complaint that makes it clear. You also have to have a real property interest, which they don't. And then you also have to show that there was a promise that you transferred your interest in the property based on that promise. Not only was there no promise or an allegation of the promise, there's no connection between the respondent and the appellant here. So there's no cause of action. Therefore, there can be no constructive trust, and therefore the notice of pendency, because it's not a real property interest, never should have been issued in the first place. But now it's completely moot because the lawsuit is gone, and without a lawsuit, you definitely can't have a notice of pendency. So for all those reasons, I'm not sure I'm out of time, but
you don't have to be out of time to finish.
Okay. Thank you very much.
Okay.
Your
Any
Honor,
further
if I may.
questions from the panel? Okay, thank you.
Your
Mr. Meister, we're back to you.
Yes, thank you, Justice Renwood. Just very briefly, I would commend to the court's attention also another case we cite, which is Nastasi versus Nastasi III. It's a 2005 Second Department case. And in that case, the court states, the appellate division states, quote, a constructive trust may be imposed by a party who has less than actual title. And they
Judge Kern, because we really haven't talked about the breach of fiduciary duty at all, the aiding and abetting. What about the argument that all the allegations that you're making about aiding and abetting breach of fiduciary duty happened after the strict foreclosure already took place?
It's wrong. Thank you for raising that and letting me respond to that. There happened to have been one act, which was the property owner signing a mortgage modification that took place. That mortgage modification was signed after the strict foreclosure. But if you look at the complaint, there are a series of allegations that, as I said, talk about the fees that would be paid by the construction management fees paid by the property owner, and those fees are aiding and abetting. There's no question about it, and they occurred before the strict foreclosure took place because there was an agreement on the part of the property owner. These are, by the way, paragraphs 46 at record 23, paragraph 56 at record 25, paragraph 104 at record 35, paragraph 122 at record 38, and paragraph 125 at record 39. In sum and substance, those multiple paragraphs allege that the property owner agreed that it would continue to pay millions of dollars of construction management fees, which of course are paid at the property level, not by the upstream entity, to Stern & Maloney. And so in the absence of property owners' agreement to do that, there never would have been a successful corrupt plan to bribe Stern & Maloney into consenting to the strict foreclosure. The lower court erred by misapprehending the complaint and solely focusing on this single mortgage modification, which was kind of a confirmatory act that took place after the strict foreclosure. The other point I'd like to make, just drifting back to the constructive trust, it is not correct, as counsel for respondent says, that a constructive trust is a remedy. It is a freestanding cause of action. And in this particular case, I think that there is a highly compelling case to be made. We have alleged and have shown with documentary evidence that the foreclosing lender bribed Stern & Maloney not to object to the strict foreclosure so that it could go through by promising to let Stern & Maloney back into the equity, which is exactly what Spruce did, and by having the property owner under Spruce's control following the strict foreclosure pay the construction management fees amounting to millions of dollars to Stern and Maloney. Based on those bribes, Stern and Maloney did not object within the 20 days, even though Spruce got letters from us saying we have a right under the joint venture agreement to approve major decisions. We object to this. We objected in our own right. We objected in the name of the strictly foreclosed entity. And so there's absolutely no question that this strict foreclosure is unlawful and corrupt. And under those circumstances, where the highest court in this state had said that there's really no limit other than principles of equity to the imposition of a constructive trust. So I don't agree respectfully that I have to have an aiding and abetting claim in order to make out a constructive trust claim. But I do think I've both made out, again, this is a 3211 motion where the documentary evidence must utterly refute our allegations or conclusively establish a defense. I don't see how the lower court's dismissal of the aiding and abetting claim, where it misconstrued the complaint and didn't understand the construction management fees component, or the constructive trust, which at least for purposes of a 3211 motion should be allowed to survive, given the gross inequity of the method by which essentially real title was acquired indirectly via this corrupt, bribed, strict foreclosure.
Thank you. Thank you both.
Thank you.
We're now going to call Kasowitz Benson, and Justice Kapnick is recused from that case, and Justice Marty Schulman is going to be vouched in. It might take a moment before we get that straight, so please be patient.
Of course.
Good afternoon. I think I'm in the loop.
That was very, very fast. So, Mr. Storch, we'll hear from you first.
Thank you, and good afternoon, Your Honor. I'd like to focus in on what I think is the nub of this appeal, and it's really a 17-word conclusion that the trial court drew in its interpretation of the federal court action that Kasowitz had brought on behalf of my clients, and which was dismissed on the grounds of statute of limitations. It's on page 12 of the record on appeal, and in that the trial court paraphrased in talking about the district court decision and said, or in other words, it was defendants' own failure to exercise minimum diligence that caused their claims against CPG to expire. And that was the basis on which the trial court determined that my clients had no claim against Kasowitz for untimely filing a malpractice claim against the Meister firm for not bringing a timely action against CPG. The federal court action that the trial court was referring to never made any finding that it was my clients that caused their claim against CPG to expire. It's nowhere in the decision, and it can't even reasonably be inferred from the decision. What the federal court was looking at was whether or not Kasowitz had timely brought the action against Meister. And in doing that, it said we have to look at two things. In the claim against Meister, we have to see when the plaintiff knew it had been injured, and secondly, when the plaintiff knew the source of its injury. Because under Puerto Rican law, those two facets start the running of the statute of limitations. Okay?
This is Judge Kern. What about the finding by the district court that had Barza employed minimal diligence and due care, it would have known that the limitations period expired in February 2014? What's your response to that finding?
Response to that is that in February of 2014, the Meister firm, which they were suing for malpractice, had already been representing Barza on the claim for 6 months. So the finding that if they had exercised minimal due diligence, it would have to then say, well, okay, they should have done something else. And the law firm that they hired, that they're suing for malpractice, The fact that they did nothing for 6 months, that is not a basis for suing the law firm. They retained the Meister firm in September of 2013 to handle these claims. The district court below found that the claim against CPG expired in February 2014, 6 months later. So what the district court said was, for purposes of determining whether this action now against Meister is timely, we're going to say you knew in February of 2014 that you had been harmed because the statute of limitations had run, because we don't see there was any due diligence that was taken that would entitle you to toll that beyond February 2014. The people that they hired to do that investigation were the very law firm that Kasowitz was suing to say, look, you committed malpractice. So that is all the district court was saying. And then it moved on to the second component, which is, when did you know that Meister could be the source of that injury, the source of the statute of limitation having been expired? And what the district court said was that was by July 28th, 2014, when Meister sat you down and said, hey, the statute of limitations has expired on this. And they said at that point, you knew the statute of limitations had expired, and you knew that it had expired on Meister's watch. Therefore, the claim for malpractice against Meister began to run in July of 2014. That's what the federal court decided.
Okay, but with regard to the Kasowitz firm, they came on, I guess, the plaintiff, the defendant got in touch with them, Barza got in touch with them, I guess in April or May or something, but they don't start billing until June, and they say that their billing is only with regard to CPG. So I don't think anything comes in, and I don't think that Barza says anything until later on in October or something, or September, with regard to Meister. It's true that the statute of limitations had not yet run on the Meister issue for a little over 30 days or so, I think they had, if you start from the time that they started billing. But if nothing, not the billing or anything else, suggests that they were aware of that they were supposed to be, that they were hired to seek look into the Meister issue, what are we supposed to do with that?
Sure. The engagement letter actually talks about all the disputes relating to the CPG matter. There is an email in the record. It's attached as an exhibit to Mr. Morales' affidavit. His affidavit appears at 225 on the record. And in that email, before, I believe it was right before Kasowitz was engaged, but it was in that June period, they say, we're not happy with the way that the Meister firm handled this matter, and we have concerns about it. And one of the things that we did argue, and we argued below, is they were engaged, taking the Kasowitz version, they were engaged to bring a suit against CPG, right? You would think that the first thing that you would do in bringing a suit against CPG is you'd look at what the statute of limitations was against CPG. The billing records show they didn't even begin to look at the statute of limitations even against CPG until October, months later. Had they looked at the statute of limitations against CPG when they were initially retained, they would have seen that it was a 1-year statute of limitation. They would have seen that the 1-year statute of limitations ran out on the Meister while Meister was handling the matter. They would have known that from the very get-go. Instead, they didn't look at that even until October. So our contention is multiple. One is the engagement letter is broad. Second, our client raised with them that they were unhappy with how the matter had been handled. And third, we think there's an issue of fact as to when an attorney is retained on a claim, whether the first thing they ought to do is take a look at and see what the statute of limitations is on that claim. And we believe that created at minimum an issue of fact as to what the scope of the engagement was.
Are there any other questions? Any other questions? Do you have anything further, sir?
I just to close this, the end result is not only was the malpractice case dismissed, but then Meister was awarded $250,000 of attorney's fees for pursuing the claim that they say was stale the moment they walked in the door. And despite the fact that Meister said, well, we didn't, excuse me, Meister, Castwood said we didn't know it because they didn't give us documents. Guillermo's affidavit says we gave them the documents. There was a disputed issue of fact as why, if what they're saying is true now, that this claim had been stale, why did it take them $250,000 to figure that out?
Thank you. Sorry, Mr. Siegel.
Yes, good afternoon, Your Honors. May it please the court, on behalf of Respondent Castwood, Spencer, and Torres.
I'd like to start where counsel left off. Kasowitz was retained sometime, I guess they started charging billing sometime in June, and it was to see whether or not there was a viable claim against CPG to investigate that. And months later, in October or November, I guess October, they finally say there's no claim here because the statute of limitations is 1 year and it's run.
So
did it really take that long to figure that out? And
well, Judge, I think yes, because we were never asked to investigate a claim against Meister when we were initially retained. But we don't need to even address that.
Counsel,
yes.
Maybe you didn't hear me. I didn't say Meister. I said CPG. You said you were retained to look into the CPG claim, which you later said was 1 year statute of limitations, but it took several months before that was revealed.
So, yes, Your Honor, we were retained in June of 2015, and I want to get back to it at some point, but Justice Sherwood and I think appellants themselves have admitted the claim against CPG ran before we were ever retained, and that should be the only issue to be decided. And I'll get back to that in a moment, but to answer your question, we were retained in June of 2015 solely with respect to CPG, not Meister. And why it took us 3 months to send a letter to CPG regarding the dispute was because we were getting information from the appellants here. Understand, an attorney's retained. The next day, they don't file a lawsuit, right? We need to talk to our clients who are working through agents. By the way, I note that to Justice Sherwood, the appellants never submitted an affidavit from Cabrera. We've got this agent, some person who is now standing in for Cabrera, trying to tell the court what the facts are. And that's how we worked. We had to go through a middleman to even get information from Cabrera in order to figure out what the dispute was. It was a property dispute in Puerto Rico. We did prepare a letter. We sent a letter to CPG, and CPG didn't want to negotiate. It was at that time in October of 2015 that the client asked us to shift gears and look into a malpractice claim. But the problem was, it was expired already. So the claim that Kasowitz brought on behalf of appellants to the district court was a tolling claim. The tolling claim was that Meister did not provide invoices to the appellants, so we did not know about the potential claim until much later, even though the statute of limitations against CPG expired 1 year after they rejected an offer from a different buyer. And there's no dispute about that, Your Honors. In the record, there are 2 instances in which appellants admit in their own sworn pleadings that the statute of limitations against CPG expired in February of 2014. There's record 88, which is their amended complaint in the SDNY action. They admit the claim against CPG expired in February of 2014, before we were retained. And secondly, in their counterclaim, where they were just trying to throw something at our fee dispute, they make the exact same allegation. That's record at 64, paragraph 77 of their sworn counterclaims in our case. They admit that the claim against CPG expired in February of 2014. Why is that so critical? Because there's also a 1-year statute of limitations against Meister, if there ever was a claim against Meister, and there clearly was not. But they had 1 year to bring that claim. Everyone agrees. It's in Judge Castell's order. 1 year under statute of limitations, 1 year statute of limitations against Meister. So if the claim against CPG expired, as it did, and they admit it did, in February of 2014, there was 1 year to bring a claim for legal malpractice against Meister. To February of 2015, we were retained in June. That should be the end of the analysis. Justice Sherwood got it. He understood it. And with all due respect to appellant's counsel, he's twisting himself into a pretzel, trying to suggest that not only do their own admissions not count, but Judge Castell's review of the case, and that was on summary judgment, he found that they should have known, because they had hired local counsel months earlier, at the same time they had Meister, they should have known that in February 2014, the claim expired. Again, Judge, I don't think that's an issue here. I think it was simple to dismiss the malpractice claim. The summary judgment portion of this, I'll speak to very briefly, because I think it's even more simple. The entire defense of our claim for fees was that we billed excessively. There was no specificity with regard to that argument. There was no actual allegation that any of our time charges or any of our invoices were wrong, were a problem. There was nothing submitted to the trial court. Justice Sherwood got it. He got it correct, and he decided there was no issue. The breach of fiduciary duty claim is beyond absurd. The noisy withdrawal argument, I don't understand at all. And I want to speak to that for one moment, and then I'll stop, Your Honors. The idea that we did something wrong by notifying the court that we were compelled to withdraw certain allegations in the Meister action is not actionable. The withdrawal papers are part of the record. We put before the court nothing more than we have a disagreement. We're compelled to withdraw these allegations, and appellants did not contest that, dispute that, object to that. In fact, they did the opposite. They consented to our withdrawal. What did the 3 paragraphs that we were compelled to withdraw talk about? They talked about the toll that we argued would extend the statute of limitations against CPG. Okay, against Meister, rather, excuse me. We were arguing because the statute of limitations had already expired against CPG and against Meister. We were arguing that because our clients at the time, the appellants here, did not know that the claim had expired, that the toll should extend. And we based that on the fact that Meister had not apparently given the invoices to Mr. Cabrera. What we learned when we went down to Puerto Rico and did a document review in their offices was that that was false. And Judge Castell noted that in his decision. He said that there was evidence that at least some of those invoices had either been received and ignored or overlooked. And so the tolling argument went out the window. And when the tolling argument went out the window, all that was left was September 13 of 2013, when appellants rejected the KPG offer, when their damages accrued. 1 year later, their claim expired. And 1 year after that, their claim expired against Meister. So again, in February of 2015, the claim against Meister had expired. We were not retained until months later. Your Honor, thank you for your time. You've been very patient.
Thank you. Mr. Storch.
Yeah, thank you, Your Honor. First of all, I'll admit it again. The CPG claim expired in February 2014. Of course, we would make that allegation. That's what happened. And Meister had been hired 6 months earlier. And the claim is that Meister allowed the statute of limitations to expire on its watch and didn't take the steps that could have extended the statute of limitations an additional year.
Mr. Storch, I'm sorry, Mr. Storch, this is Judge Shulman. I hear what you're saying, and this is what I'm struggling with here on this record. If Mr. Cabrera became aware that let's assume he became aware in July of 2014 that the CPG claim expired.
Yes.
When he went to the Castawitz firm in April, May, putting aside it got more formal in June of 2015, how is it possible for him to approach that firm and not come in with guns blazing, say, boy, this Meister firm that I retained to go after a former business partner in a failed deal, they blew it. This is what you folks need to do. Whereas what I'm sensing from the record and the communications was, oh, it's after the fact. See what you can do to restart negotiations and get CPG back in the loop on this failed deal. It just logically makes no sense for you to go to a new firm and not come in with that affirmative presentation and not just have some obscure email saying, oh, we're unhappy with the way Meister was handling this. Does that make sense to you, sir?
Your Honor, it really does. First of all, we're not dealing with lawyers. My clients are not lawyers. Secondly, they raised it right at the get-go that they were unhappy. One of the things inconsistent with that email is they were also sending the Meister engagement letter to show them what they had retained Meister to do and why it hadn't been done. So it wasn't as if they had they didn't raise it. They raised it from the get-go. They went to lawyers and they said, look, this is what happened, and we were unhappy with what they've done, and we think we have a good claim against CPG.
But that wasn't in the retainer agreement.
Well, but the retainer agreement says all disputes relating to CPG. I think that they laid it out for the attorney, and I think that frankly, and I think this is an issue of fact, is the first thing you do is you come in, you say I want to sue CPG, is you look at what the statute of limitations is against CPG. You don't wait months to determine what the statute of limitations is, and then go back and say, oh, well, the statute ran. Now, a lot of the other stuff also that you're hearing now about attacks on the client is what they did in throwing the client under the bus in the federal court. All right, the talk about, oh, we finally discovered these documents when we went to Puerto Rico and looked at documents. That is more than a year and a half after they were retained. There is email which we put in the record where they're asking our client for documents and the client is sending them the documents. Right? It wasn't until they suddenly decided that, oh, the client withheld something from it, is when the Meister firm in the federal court made a motion to disqualify Kasowitz and said Kasowitz was guilty of malpractice by not having brought the action on a timely basis. Then suddenly the client became the villain. Suddenly this respected ambassador, with a lifetime of service, suddenly became someone who was deviously concealing documents from them. So this attack on the client is just of a piece of what went on in the federal court, which frankly was unfair to the client. If you look at the email traffic, which is attached to the Guillermo affidavit, they responded to every request that the Kasowitz firm made for information. It was that they just didn't do their job in going and looking at servers and whatnot, which they finally did in January. I think if I may, Justice Shulman, just one final point. Let's take, your position that, okay, they didn't tell them, to say, hey, go against the Meister firm, you should come in guns blazing. How do you run up $250,000 of fees pursuing a claim that you now say, well, it really, that's not what you came here to retain me for, and it had run out months before that we'd even become involved? How does it take $250,000? And when we raised that down below and said our objection is not, to explore every line item, which is very difficult because they didn't follow their own contract in rendering bills on a 30-day basis. They did it months after the fact. How can it be they're entitled to be paid for work that they now say was pointless? There's at least a factual issue as to why is it that you didn't discover that this claim was pointless. There's a factual dispute as to what information were you given? Were you really denied information that you needed for that point? Those are all facts. Those are all raised by the affidavits below. But instead, the trial court said, no, you have to go every line item, despite the fact that some of these bills you didn't get until 90 days after the services were rendered, and tell us why you think you spent too much time on this particular thing. And I think that's not what the law was, and I don't think that's appropriate under these circumstances.
Thank you. Thank you both.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
We have another switch where Justice Gesmer, the next case is Martinez versus DiFiore, and Justice Gesmer is recused, and we'll get Justice Kapnick back.
I'm back.
Okay, great.
Sorry, it takes a minute.
Yep, we understood that.
Thank you.
Mr. Kathawala?
Thank you, Your Honor. May it please the court, Renee Kathawala for the appellants. At issue in this case is a simple and crucially important non-discretionary rule that the chief administrative judge in New York State passed in February 2001, almost 19 years ago. The crucial issue on this appeal, Your Honors, is whether this rule is discretionary or non-discretionary. We believe, based on the language of the rule, the case law that defines this area of the law, and what even Justice Hagler did to evaluate whether the respondents were in compliance with the rule, is absolutely clear that the rule is non-discretionary. It is subject to the mandamus provision of Article 78.
So, counsel, I agree that there certainly is a strong aspect that is non-discretionary, but there are many discretionary aspects within the statute. It's almost that the discretion is tempered by the mandatory language. For example, where a judge within that 90-day period that the trial is supposed to take place on willfulness has the ability to grant an adjournment for seeking an attorney. So that's a discretionary period within there. And there are, there are multiple opportunities for that to happen. So how do we look at this as non-discretionary and apply mandamus where we have this discretion within the statute that's permitted?
So, yes, Justice Renwick, I believe that first of all, in our amended verified petition, we made clear, and throughout the litigation, we made clear we're not intruding on any of the good cause sections. I think the rule has to be focused on subparagraph B, which says, without any discretion, after service of the petition, the hearing must commence within 30 days, and the hearing must be completed within 60. The two pieces of discretion, as Your Honor just pointed out, relate to adjournments after either right before the hearing starts or in the middle of the hearing, and you either get a 14-day adjournment or a 7-day adjournment. We're not
Won't
seeking.
that extend the period of 60 days or 30 days or whenever that discretion is implemented?
The rule does not say that that period is extended, and the reason for that is because the critical issue here is that this rule is not some rule that was created by the administrative judge out of whole cloth, but rather it comes via a federal mandate. The federal government, in order for New York State to receive funding with respect to public assistance, they must create this very expedited process. That's a condition of the funding. And New York State certifies that the state is in compliance and has certified that the state is in compliance. So the 90 days is not, apologies, Your Honor, is not discretionary. What is discretionary is within that 90-day window, there are opportunities for the fact finder, and we don't wish to intrude on that in any way. If the fact finder finds that a adjournment needs to be given to obtain counsel or for any good cause, that adjournment should be granted. We're not intruding on the ability of the fact finder in these cases to exercise discretion to run the case as any fact finder would. But I think it's critical to say that we're not coming to this court with clients who have had cases last 95 days, 100 days, even assuming the administrative rule allows for extension beyond the 90 days. What we're talking about are delays of months and years, literally years, multiple years. And even during the pendency of this case, there were multiple clients that I represented that had cases that extended for more than a year, for literally 2 years and 7 years, respectfully. These are not isolated deviations from the rule. In fact, the amici, her justice, put in a study that they did of 300 child support cases. Now, admittedly, that study didn't focus exclusively on violation cases, but it obviously incorporated violation cases. And they found that the average length of time is a year. And I think the other critical issue here is that OCA really never has monitored this rule until we brought it to the attention of Judge Marks shortly before commencing this Article 78 petition. They didn't keep statistics at all. They had
Counsel, excuse me, isn't one of the things that you're requesting in your petition is to compel the respondents to track the compliance? And what under what basis statute can we compel OCA to track compliance? I mean, we don't have any power to do that, or where do you claim we do have power to do that?
Well, it is a way. I mean, I think the power comes from Article 78 itself, which is that there's a non-discretionary obligation here to have these cases concluded within 90 days. In order to do that, the court system, which is seeing cases extend months and years past that deadline, has to implement processes to ensure. And in fact, the respondents in their affidavits,
even if that's true, I mean, what again? What power do we have to compel respondents to track compliance? I mean, I think your applications, your requests to them, is just as efficient, but I don't see where we can compel them to track compliance. That's what I'm saying.
Well,
which is, I think, part of what you're asking in your petition.
Well, what we're ultimately asking for is that they comply with the rule. We offer that as a mechanism to ensure that the rule is complied with. And I think within the Article 78 mandate, where because the Family Court Act requires the chief administrative judge to appoint sufficient numbers of magistrates to ensure that the rule is complied with, that part of that must involve tracking. And her justice does a good job in their brief of drawing attention to the necessity of data and how data informs whether a rule like that is complied with. So I think it's part and parcel of the remedial measure that the court should have issued below that said you must comply with it. We're not dictating to OCA, you have to do this, you have to do that in order to comply with it. But the rule is non-discretionary, and therefore there's a power within that process to compel. And I would draw your attention to the Cisco versus Levine case, which we think is very similar and all fours with this case, where there's a similar rule requiring executive judges to process appeals within 60 days. And the court issued a Article 78 petition and required the 60-day period to be complied with in each appeal. This is no different than that case. There's absolutely nothing distinguishable about these facts than what the facts presented in Cisco. There were deviations, significant deviations in the processing times of those cases. And in this case, we have no evidence from the respondents. And I think it's critical to look at what evidence did they submit of their compliance with the rule. They submitted ultimately.
So this is Judge Kern. Wasn't the Cisco case distinguishable? And the judge below actually spent a lot of time on that, and that the respondent that was not acknowledging the responsibility and saying that they did not have the responsibility. So all the court was in effect doing was saying, yes, you do have the responsibility under the rule and interpreting the rule. Whereas in this case, they are acknowledging they have to comply with the rule and arguing, and not arguing that they're not responsible for complying with the rule. So it's a sort of a different scenario, which goes to the issue of having to actually track whether or not they are complying with the rules they say they are.
Your Honor, I think that's a distinction without a difference. Whether the respondents in Cisco said, we believe we have to comply with the rule and we haven't done anything, or whether in this case the respondents say we have to comply with it and we're doing something about it. The question is the outcome, right? For the petitioners, for all of the custodial parents who bring these violation cases and have their cases extended for months and years, that doesn't really distinguish why the respondents have failed in their obligation to enforce this non-discretionary rule. And I think the critical question, and I sort of go back to the question that was asked earlier about the good cause exceptions. We are not asking to intrude on any decision-making of any jurist. We are saying you just need to have the hearing commenced within the rule. You have full discretion to issue adjournments. But the point is that when cases last for 6 months, years, there has to be a remedy for it. And the remedy can't be
Counsel, if it lasts 6 months to a year, we would have to go look at the record in each case and see why it's lasting that long. Is it because judges were granting discretionary adjournments? Why was that occurring? And who would do that? Who would monitor this in the way you're suggesting? You keep saying, oh no, we don't want to interfere with adjournments, but isn't that part of why the cases are not getting decided within the 90-day time frame, because courts are actually granting adjournments within their discretion?
No, again.
To get counsel or for whatever reason?
No, Your Honor, because the rule, subparagraph B, again, language, and the practical effect of that language, it's unequivocal. The cases must be completed in 90 days or less. So, yes, there are adjournments possible. And as Judge Siegel says in his amicus brief, the practical effect is this is not an appeal of cases where there's slight delays of a few days. These are significant delays that impact the children in significant ways. So the court, in monitoring whether respondents are in compliance with the rule, don't have to get involved with the good cause adjournments at all. The critical thing, I think, if you look at the September 24th hearing before Judge Hagler, he went through his analysis and he could easily determine was a adjournment given. He excludes it from the computation of the time. And even there, the data showed that there was no compliance with the rule. This was years after implementation of the rule. And in fact, the data from Queens County, the respondents submitted data that showed they had 0 cases greater than 90 days. In a sample size of 10, 3 out of the 10 went beyond 90 days, and that was excluding good cause adjournments. So I don't agree that somehow any reviewing court or the trial court in issuing a mandamus order must get in the weeds about adjournments or not. The fact is, you just look at the total length of time and determine if there were adjournments granted and there were good cause, you tack it on and that's it. So the implementation is clear. And ultimately, what we're saying here is if there's no remedy for a case that lasts a year or two, then there's no accountability on the part of the court system to the litigants who are trying to simply recover child support for their children. And there must be a remedy, otherwise there's no accountability at all and the rule of law falls apart. So, you know, the Court of Appeals has made clear mandamus is appropriate where there's no interference with discretionary acts by fact finders. Here, we're not asking the trial court to interfere with any discretionary actions. What we are asking is for the respondents to implement processes to ensure compliance. And ultimately, what we're asking for is a mandamus order. You must get into compliance.
Counsel, but wouldn't necessarily, if judges were allowed to exercise their discretion in giving an adjournment, it may not just be for getting counsel, but someone may be sick, a client could be sick, they could have an emergency. I mean, we know there's numbers of reasons. How are they going to get it done within 90 days? I mean, the two things seem to intersect. I mean, you're making very good points. I don't mean to suggest that you're not and that these aren't important issues. I don't want to suggest that's what I'm saying. But I'm just saying that how is the mandamus not going to interfere with the discretionary acts of the judges? Because it seems that if you have to start it within 30 days and then complete it within 90, so that gives you 60 days to do it. And if somebody needs an adjournment and they bring it back and somebody else may have a problem, you know, it is going to intersect, although I understand the point of what you're saying, but it seems to me technically that doesn't work.
Well, respectfully, I think what you're talking about, and I got the same question from Justice Hagler below, as it related to 20543E. The reality is the cases proceed based on the time frame that's in subparagraph B. They're like whether a client is sick, right? that's incorporated within that 60-day period. So you schedule the hearing, the client is sick, you get an adjournment 7 days later, you complete the hearing that 7 days later. It should not interfere. There are very few circumstances, if any, that should cause the case to go past 90 days. And again, the critical thing is not, does it go 91 days or 94 days?
I
the critical
understand.
thing, sorry, Your Honor.
No, I understand what you're saying.
So I really feel that to say somehow that this is an unenforceable Article 78 petition request doesn't really look at what's happening in the family courts as a practical reality, which is that these cases are supposed to be scheduled within 30 days. They're supposed to be completed within 90 days. The fact finder has full discretion to grant adjournments for cause, but the point is that the federal government said we can't have people go on public assistance because they're not getting child support, and you, New York State, need to certify, like every other state in the nation, that you are complying with this rule. There's no ambiguity about the 90-day period. It's the federal regulation that we cite in our brief is very clear. States must comply with it, or they risk either getting penalties assessed against it or not. So and I do think it's very important to understand that these clients are taking time off from work. They're owed $11,000 on average. There's $8 billion of child support outstanding in the state of New York. This is a crisis. And for the court system to shrug their shoulders and say, well, we're doing the best we can, there has to be compliance with mandatory rules. Otherwise, the litigants who are the clients in our system will lose complete faith. And I know from personal experience, litigants give up because these cases drag on. Their adjournments are not 7 days or 14 days. They're 3 months. They're 6 months. That is not what the rule contemplates, and that's what we're trying to address here. So it's not the anomalous, oh, a client came in and was sick or called in sick, and it needs to be adjourned. What we're asking for is an order saying to the respondents, you need to ensure that these cases are processed in 90 days. And we believe the case law supports it. And I would add that the result of Justice Hagler's decision is he even dismissed the petition as it relates to things where there can't be a claim for a good cause. For example, the issue that got raised in Carmen R, 20543F, which puts a responsibility on the support magistrate to issue findings of fact within 5 court days. There's nothing that should prevent that rule from being complied with in a timely fashion. 20543G, the findings of fact shall contain the following, and it gives a list of things that are supposed to be in the findings of fact. Again, that rule is very clear. There's no good cause exception. So the Respondents' Council has tried to make this case about good cause adjournments. What this case is about enforcing a mandatory rule that is clear in its language. The Court of Appeals has said repeatedly in mandamus cases, if you're not interfering with the discretion of a fact finder, it is subject to mandamus. And Justice Hagler proved that this can be done very easily. You could look, if it's a good cause adjournment, it's not counted in terms of the days, but ultimately it's simple. You look at the start date, the end date, it should be within 90 days. And we are troubled, I have to say, about the evidence that was submitted by the respondents in this case. We agreed that there was a statistically significant number of cases that needed to be reviewed by Justice Hagler. The respondents, out of 60 cases, only 28 ended up being willfulness cases. They resubmitted that evidence as part of their answer after Justice Hagler had pointed out to them that there were only 28 out of 60 cases. So there's absolutely no record here about concerning the substantial compliance of the respondents with this rule. And we feel that at a minimum, as an alternative measure of relief, that we should be entitled to discovery to get access to the records to determine once and for all, are the respondents complying with this mandatory rule or not? To allow this case to be simply affirmed, the other thing I have to point out is I filed
Counselor, you're already way over your time, so if you would just, if you have a thought, just wrap it up in the next.
Okay, Your Honor, thank you. One
You
more
have,
thought is I cited a case on page 9 of my reply brief. I filed an Article 78 case against a support measure where my client, who's also a petitioner in this case, there was a wild delay of the hearing being conducted, and the Supreme Court justice on that case held that the rule is completely discretionary and she can't interfere, even in an individual case, which is in conflict with Carmen R. that this court has issued. And I feel like the principle has to be applied consistently also to the respondents, to them, and in individual cases also. So thank you, Your Honor.
Thank you. Mr. Greco?
Thank you. Supreme Court correctly dismissed the mandamus petition because Family Court Rule 205.43 requires judges and support magistrates to exercise discretion. Determining.
So, I just want to ask you what counsel is saying, and I'm sure you're fully aware, is that within the 90 days is a hard and fast rule. The 30 days, you commence it, that's hard and fast. Finish it within 60 days. That's hard and fast. Do whatever you want with your adjournments within that period, but make sure that you get it done. So in other words, if someone needs an adjournment for an attorney, maybe it's not going to be 2 weeks, maybe it is, but it's one adjournment within that entire 60 days, or I'll say 90 days. So why can't we look at it in that way, as do whatever you want, you have your discretion, but you have to do it within that period?
Because the petitioner's reading of the regulation is just incorrect. The adjournments are not limited to going up to 90 days. Now, it may in the vast majority of cases are completed within 90 days. But the suggestion that the discretion stops at the 90-day mark is simply an incorrect reading of the regulation.
So what is that mandatory period for? What's the purpose of that?
I don't agree that the rule as a whole is mandatory, but the rule requires the exercise of discretion, and therefore, under well-settled precedents.
What does the mandatory aspect mean? If it says you have to commence it within 30 days, does it mean you don't really have to? Or does it say, when it says you have to complete it within 90 days, what does that mean?
It means that.
So, it sounds like you're not giving any countenance to the mandatory aspect of it. What's a judge supposed to do with that?
Because discretionary adjournments can be granted even beyond those points. The rule is mandatory in the sense that judges are bound to comply with it. But in choosing how to apply the rule, it requires an exercise of discretion. I want to add that in addition to the discretion that is built into Rule 205.43 itself, there is also Rule 205.1b, which indicates that any provision of the regulations can be waived for good cause shown or in the interest of justice. Furthermore, the relevant statute under which all this is taking place, under Family Court Act 435B, which unlike the regulation at issue here, this is a statute, requires as a statutory matter that adjournments be granted for factual inquiries, including the parent's capacity to pay. So the suggestion that this by reading in isolation subsection B, one can read all discretion out of the regulation is simply an incorrect reading. The mistake that the petitioners are making is that they are conflating the idea of a discretionary rule with a rule that is merely advisory. We agree that the rule is important and binding, and that judges must comply with it. But that doesn't make it non-discretionary. If an adjournment can be granted, that is a discretionary decision, and therefore not a subject for the grant of mandamus. And because the petitioners do not seek to compel the respondents to perform a ministerial act, mandamus is unavailable. The court should affirm on that basis and should go no further. However, even if mandamus were available with respect to Rule 205.43, Supreme Court rightly concluded that it would be unnecessary to grant mandamus. The petitioners point to nothing in the record showing that the respondents are failing to make every effort to comply with the rule.
But what about that? What about petitioners' arguments? A couple of them that he's not here fighting about the case that takes 93 days or 95 days. He's here complaining about these cases that take a year. He's here complaining about not a 7-day adjournment or a 14-day adjournment, but a 3-month adjournment. He's here complaining about the cases that go on for such a long time. And what about the federal mandates or guidelines so that we can get that New York, not we, but the New York State can get the support that they're supposed to get by showing compliance when you're very much not able to show compliance in reviewing them. I mean, those are the concerns that you seem to be pushing over a little bit. It does say it must be concluded, and I understand we've all been trial judges. We are all judges. We understand all the volumes of things that are there, but I you know, there's a big concern here, and you seem to be sort of, you know, smoothing over that a little bit too much, perhaps.
Everyone takes this rule very seriously, and everything in the record shows that the family courts are taking the rule extremely seriously. To address the federal rule that you're referring to, Justice Kapnick, there's nothing in that rule that requires a specific deadline. It merely requires states to adopt some sort of expedited procedures. There is nothing that's, and Justice Hagler was very explicit about that in his decision. The error that the petitioners are making is that you cannot disaggregate discretion from the granting of adjournments. Because the application of the rule inherently puts judges in a position where the exercise of reasoned judgment could typically produce different acceptable results, that is the standard for a rule being discretionary. And my adversary suggested if something is discretionary,
Counsel, you're still not answering. Counsel, you still don't sound like you're directing your response to Justice Kapnick's question, and I hope I don't get it wrong. But I think it's sort of taking into consideration the amicus brief, her justice, and the kind of statistics that are spoken about there, where the majority of these cases are going well over the 90 days. Do we simply say everybody's aware of it, so we don't have to do anything about it? Everybody's aware of it, so what's being done about it to prevent this from being more the rule as opposed to the exception? That's really the question.
So the delayed cases are the exception. And as far as what is being done about it.
No, I was saying the other. From what this is showing, the delay cases may be more the rule that's coming about rather than the exception. The record of these cases are being done within the 90-day period. And it's not simply going to 100 days, I'm sorry, not 90 days, but 100 days, let's say, is going to, 12 months.
So the record on appeal doesn't support that. And I would say furthermore that the steps that the respondents have taken showing how seriously they take the rule include the creation of new support violation parts, extensive training of support magistrates, distribution of both written materials and live training about the importance of meeting deadlines. Starting at page 420 of the record, it shows the great detail and emphatic language that the respondents have used in explaining to support magistrates the importance of meeting these deadlines. There are regular conferences with support magistrates emphasizing the importance of deadlines. There's also now quality assurance, as shown at page 452 of the record. For example, the 8th Judicial District, and this is just one example, now has adopted a process of drawing a random sample of cases every month to determine whether cases are in compliance. What this brings us back to is the Court of Appeals' decision. What this brings us back to is I'm sorry, Your Honor?
No, go ahead.
Oh, thank you. What this brings us back to is the Court of Appeals' decision in Bruno versus Codd, is that even where a mandamus petition is justiciable, and this petition is not because it requires the exercise of discretion in the granting of adjournments, but even where a mandamus petition is justiciable, relief is not appropriate where the respondents have demonstrated that they fully understand their obligations under the rule and are making every effort to comply, and that is this case. I want to address also my adversary's suggestion that
let me ask you something. What about counsel was referring also to, for example, the 5 days that a decision has to be in writing and include all the facts and has to be done within 5 days. There's no discretion in that aspect.
So I actually want to use this moment to distinguish the Carmen R. case that my adversary is relying upon. Because Carmen R. wasn't about adjournments. It was about a support magistrate who failed to follow the provision in the rule stating that a finding of willfulness must be accompanied by a recommendation as to incarceration. Here we're dealing with the adjournment provisions of the rule, which expressly require support magistrates to consider good cause, and that cannot be a ministerial determination. And again, I want to emphasize, the fact that something is discretionary doesn't mean that we're saying that the rule is advisory, which is the equation that my adversary is trying to make. A discretionary rule is that one that requires a judge to perform an act that is more than merely ministerial. And deciding when adjournments are necessary is always something that is more than ministerial. So it cannot be it cannot be something that is amenable to mandamus.
Thank you.
Thank you.
Your Honor.
Mr. Cathawala.
Thank you, Your Honors. I have to say I really take issue with what counsel said, that he said, quote, "Delayed cases are the exceptions." There is nothing in this record that supports that. In fact, he said there's nothing in the record that supports these cases extend beyond months and years. Well, in fact, Appendix 813 to 14 that the respondents actually requested to be put in the appendix has a list, a chart of the 18 clients that I represent who faced delays of months and years. And in fact, 8 of those are cases that were pending at the time of oral argument in January of 2020. The data that, to the extent data exists, it shows, Dr. Baerstock said without any difficulty, that the data the respondents submitted to a 100% certainty was unreliable. And so we feel very strongly that statements like that have to be corrected. And it would be, I think it's very inappropriate for counsel to make that assertion when their own data has been proven to be untrue. And Justice Hagler indicated there were clear errors with it. And Justice Hagler went on to say, oh, I reviewed it. It looks fine to me. Well, the reality is those cases that he reviewed, the 28 willfulness cases, took 42% of them took longer than 90 days and much longer than 90 days in many of those cases. But the fact of the matter is there's no statistically significant evidence in this record to support anything about respondents' compliance with the rule. Mr. Grieco said that somehow that the court should not look at subparagraph B as a absolute outer limit. He said there's nothing that suggests the cases have to be completed in 90 days. Again, there's no authority for that. The rule is clear on its face. It's unequivocal. It's unambiguous. It requires the support magistrates to process the cases within 90 days. You can't get around that clear statutory language. And Mr. Grieco did what he did in his brief. He tried to distinguish Carmen R by saying somehow it wasn't a case about discretion. No, Carmen R was a mandamus case trying to get the support magistrate to actually issue findings of fact. The support magistrate in that case did not issue findings of fact, so I had to come up to the appellate division to have an order issued to issue the findings of fact. They were so delayed that it took the entire court process of more than a year for me to get findings of fact. The citation to 205.1b again is a red herring. You can go into every family court case there's no reference by any support magistrate to 205.1b, and they can't point to any. And by the way, if a support magistrate relied on 205.1b, that would be a good cause adjournment. We wouldn't be questioning that. The fact of the matter is they've never relied on it because it was only us who has caused the system to actually start thinking about the rule. But the fact that they're thinking about the rule is not a defense. The question is, have the respondents complied with the rule? The unequivocal answer is this court cannot point to a single piece of evidence, not a single case that suggests they're in substantial compliance, as the governor of the state of New York has certified to the federal government that the state is in substantial compliance as recently as January of 2020. Substantial compliance means 75% of the cases are processed within the 90 days. And in fact, the federal regulation, if you read it, does in fact have an outer limit. They say 60 days. because they have an alternative, one where there is no court process for violation cases. In some states, it's done administratively. In court cases, it allows up to 90 days. So the evidence is overwhelming that the trial court here got it wrong. This was a non-discretionary rule. The evidence is overwhelming. The 18 cases that the 18 clients I've represented, 8 of them while I was litigating this case, wild delays, months, years.
Thank you.
And so for this court to shrug its shoulders and say, that's fine, respondents, you can just continue on. You're making good efforts. We think that would be an abuse of discretion. It would violate all principles of rules of law. And we ask for the foregoing reasons respectfully submitted in our briefs that the court reverse and remand to the trial court. Thank you, Your Honors.
Thank you. Thank you both. This was the last case of the day, and it concludes oral argument for today. Court is adjourned. Thank you.